My lord, but I am mentioning one matter, my lord, item number 3. Your lordship, please to fix on 21st July. But my lord, my learned friend madam telephoned me that here serious leave, that's why he has not come to court this week. Today, well, it is Pathar.
I can't get you. Come again, please.
Well, I am not in this matter.
Then
I am mentioning on behalf of the learned advocate for the opposite party.
what's the issue?
But he said, your lordship, please to fix on 21st. He said, but I don't know. But today matter is in the list, madam.
Matter is running in the list today.
Today, yes, ma'am.
Item number?
Item number 3. Pathar matter.
Then it will be taken up today.
Madam, he has not come to court. It was fixed on 21st.
Then wait for your turn to come. Yes. Yes. Application? You haven't served.
Why?
No, you serve and come.
2008 matter, I could not get the name.
Send it directly to the parties. Don't try to do anything keeping the other side in dock. Please.
My lord, upon notice I am mentioning, earlier also mentioned, my lord.
Criminal matter.
No, civil matter, second appeal, my lord, where the Honorable Justice Pattanayak was pleased to direct to bring the LCR upon payment of the special messenger cost. I am the appellant, I have paid the my lord cost. And it was mentioned before your lordship on 9th of June.
I have given direction.
Yes, your lordship kindly. My lord, let the matter appear under the heading to be mentioned. Any day convenient to your lordship. My other side is here.
Yes, what's the stumbling block? Why LCR is not coming?
Well, direction is there. I have complied.
No, anything behind the direction. Be frank, nothing.
No, paper book is ready, sir.
Department.
Bibliography.
After service. Sorry.
Not appearing in the list, that's been filed in 2021. But it is not appearing.
You serve and come back. Your prayer will be acceded to. Only thing is you have to serve and come back.
Under compelling circumstances, may I
at 1 p.m. your matter will be taken up at 1 p.m.
1 p.m.
Not yet. Yesterday's mentioning,
Yes,
which they did. My lord, if they put us to notice at
upon notice.
Yes, upon notice.
Lord, if they put us to notice at 9:33 a.m. in the morning.
No,
No, please, Mr. Ray.
At 1 p.m. please.
One after the other.
At 1 p.m.
I will exercise balance.
Yes.
Very well, you exercise whatever.
At 1 p.m.
1
please.
no.
Yes, call the list.
Deeply obliged. This is not right.
Appeal is accepted, impugned judgment is set aside. Yes. Appeal is accepted, the matter will go back on remand.
Lordship, give any time limit?
No time limit. Don't seek adjournment, it will be done.
No, my lord, I give her to seek, sir. Deeply obliged.
Yes. Delay of 101 days condoned with cost of rupees 15,000. Item number 3 contact. Oh, okay. Zero. Item number 3. You are for the other side.
Yes. In the earlier occasion, the last matter was
did we fix the matter on 21st of July?
21st July. On that date, the,
So it will be appearing on 21st July. Your friend has some difficulty today?
and Sanjay Mukherjee was there
Maybe,
the last day.
maybe
And in
someone
his
appeared,
presence, matter was
someone appeared and expressed difficulty. I shall take up the matter on 21st.
21st.
But 21 তারিখে রাখুন তো।
My lord, on that day, there is a huge gathering in the 20.
Are you going to participate
No, no,
there?
no. That the matter may, no, not to personally advise resolution may be passed. That is what.
That may be your resolution. What is to me? I may not accede to your request.
On that day, generally,
Don't say
Resolution.
like that. It's mere request. If we decide not to accede.
matter
Anticipating that, can I keep my diary blank?
on that day.
How are you
happens.
saying this?
Okay, my-
Can I pass any order anticipating there will be huge gathering, so lawyer may not appear, so there will be no case?
that is
Be
why-
sensible. You come on 21st and have your difficulty, then it will be considered. Whatever request is coming, it's a request merely. That is not a mandate upon the court, please remember.
Call the list.
কি আছে 21 তারিখে? হ্যাঁ? মিছিল?
I would kindly remember that section 11.
Yes. I'm only interested to lend my ear to your friend only. It's a very unique situation.
Yes, my lord.
Absolutely suffocating circumstances.
Yeah.
How could you come out of this? Let me
Absolutely.
see.
Absolutely.
Then
Well, only I can say that there are some ruling of apex court.
ruling.
Some ruling is old aged. And from that view, I can say that this
Oh, who is the appellant? You or
is there.
you are? So let him have
Yes,
his.
yes.
Yes.
Suit for eviction, my lord, of licensee was filed by my client, my lord.
Hmm.
Wherein, my lord, the defendant has filed a counterclaim. My lord, kindly comes to my lord paper book page 1.
Hmm.
It's not that lengthy judgment, my lord. When I read it, my lord.
Hmm.
A plaintiff's case. The plaintiff's case is in brief is that the entire suit property at one time belonged to Muhammad Masum Malik, who had sold the said property along with other landed properties to Srimati Mayarani Shamanto, the defendant of this case, on execution and registration of one deed of sale being number 214 for the year 1989. While using, enjoying and possessing the said property as absolute owner and occupier by construction of one RT shed, converting the suit property and running on workshop thereat, the defendant of this suit for a lawful necessity had sold out the suit property by running an workshop there at the defendant of this suit for a lawful necessity had sold out the suit property to the plaintiff by virtue of a registered deed of sale executed on 24th of May 2001 and registered on 25th of May 2001 in the office of the sub-registrar at Bargachia, Howrah. By that deed of sale, the plaintiff was handed over and delivered the khas vacant possession of the suit property sold by the defendant. In spite of clear declaration in the deed of sale dated 25th May 2001, the defendant of this case as vendor had faced much trouble at the time of delivery of khas possession of the suit property to the plaintiff. Sorry, since the defendant had been running a workshop and the defendant could not hand over immediate possession of the suit property to the plaintiff. Hence, after execution of the deed of sale and absolute transfer of interest as aforesaid, the defendant approached the plaintiff to arrange the suit property for the defendant for a temporary period. Thereafter, the plaintiff granted the license with permissive occupation of the suit property temporarily without any license fee, out of sympathy and good relationship. But there was a specific condition that the defendant would vacate the suit property as and when the plaintiff, being the owner licensor, would ask the defendant to deliver vacant possession of the same. There is further contention of the property that plaintiff preliminary the license to use and occupy the suit property was granted up to 30th Choitro 1409 BS on clear assurance that the defendant would vacate the premises whenever it will be demanded by the plaintiff. And after the expiry of 1409 BS, the defendant requested the plaintiff to extend the license, and it was finally extended up to 30th Pous 1414 BS. Thereafter, the plaintiff asked the defendant to vacate the suit property, but the defendant appears to be very much reluctant to pay any heed to the request of the plaintiff and made no arrangement to vacate the premises. Finding no other alternative, the plaintiff was compelled to revoke the license and also sent a letter to the defendant through her authorized agent and Lane advocate under registered post with AD on 10th of January 2008. The defendant also received this said letter on 10th of January 2008 by endorsing her signature over the postal AD card, but refused to vacate the suit property, and thus the defendant, in spite of due tender and service of notice, had not vacated the suit premises and had not delivered the possession of the plaintiff. Hence, this suit. A defendant's case. The defendant appeared and filed the written statement and denied all the material averments made in the plaint. The defendant, in his written statement, categorically pleaded that the suit is not maintainable in facts and law. He also stated that the suit is false, malafide, motivated, speculative, and harassing one. The defendant, in his written statement, averred that the defendant was the owner of the suit property and the defendant is not the licensee at any material time. It is also denied that the defendant appears to be very much reluctant to pay any heed to the request of the plaintiff and made no arrangement to vacate the suit, vacate the premises. Rather, the defendant expressed her disinterest in the delivery of vacant possession to the plaintiff in clear defiance of her sincere promise. It is also denied by the defendant that the defendant received the said letter of revocation of license dated 10th of January 2008 by endorsing her signature on the postal AD card. So the question of vacating the suit property and delivery of possession does not arise at all. The defendant, in his written statement, stated that the defendant was an illiterate person. The defendant somehow put her signature due to need of money. The defendant had requested the plaintiff for giving loan. The plaintiff told the defendant that she will accommodate the loan of rupees 67,000, subject to condition that the agreement would be registered. The defendant, on good faith, has put her signature on the document executed on 25th of May 2001. The plaintiff had demanded rupees 1,10,000 from the defendant to hand over the possession of the defendant. The defendant paid rupees 90,000 to the plaintiff. It is submitted an agreement was executed between the parties on 14th of September 2001. Accordingly, the defendant paid rupees 60,000 to the plaintiff. He further paid rupees 30,000 and as a result, rupees 90,000 was paid by the defendant, but in spite of that, the plaintiff did not execute any deed of conveyance in favor of the plaintiff. The defendant further contended that the deed was not the out and out sale, but it was a loan in substance, and hence the LS deed of sale has not been acted upon. It is submitted that the defendant had requested so many times to the plaintiff for executing the deed of reconveyance, but the request of the defendant was turned down by the plaintiff on 18th of August 2008, and hence the defendant is compelled to file the instant counterclaim. Hence the defendants have prayed for dismissal of the suit. My plain case was that I have purchased the property. It was a workshop. The defendant could not vacate the property. She asked for some time. I have allowed it. When I have asked her to vacate, my lord, she has not vacated, and I filed this suit. They have come up with the plea, that, my lord, along with a counterclaim that it was a loan in substance. As such, my lord, declaration to such effect was prayed for. But issues, my lord, issues, it would be required to, my lord, show the issues. Upon going through the aforesaid pleading of the respective parties to the suit, the following issues are framed. One is the suit filed by the plaintiff and the counterclaim by the defendant maintainable. Two, does the plaintiff has any cause of action to file this suit and the defendant has any cause of action to file the counterclaim? Three, whether the plaintiff is the owner of the suit property. Four, whether the defendant is the owner of the suit property. Five, whether the defendant is a licensee in respect of the suit property. 6. Is the plaintiff entitled to get the decree as prayed for? 7. Is the defendant entitled to get the decree as prayed for? 8. What other relief or reliefs is the plaintiff and the defendant entitled to? Alright. Evidence adduced to prove the plaintiff case, only the plaintiff deposed as PW1. On the other hand, to prove the defense case, the defendant and 2 others deposed as DW1, 2, and 3 respectively. During the course of examination, following documents were marked. Kindly see, my lord. First one, my lord, was sale deed executed by Srimati Maharani Samanto.
Hmm.
Kindly see the second one. This was sale deed executed by Muhammad Masum Malik in favor of Maharani Samanto. That was the original one, my lord. It was with me. 3, Exhibit 3, LR record of rights in the name of Nirupama Kunti. 4, 4/1, 4/2 are 3 dakhilas in the name of Nirupama Kunti. That's the plaintiff. Exhibit number 5, notice for revocation of license. And exhibit number 6 and 6(1), AD card and postal receipt. My lord, they have also tendered some documents, my lord. Kindly see exhibit number A, signature in the agreement dated 14 September 2003. Exhibit number 2, revenue receipt. Exhibit number C, with objection, Panchayat receipt dated 30th of December 89. Gram Panchayat receipt dated 8 January 2011 and 9 April 2013. Decision with reasons. Issue number 1 and 2. Both these issues are taken up together for the sake of brevity and convenience. Perusing the plain written statement, counterclaim, and the evidences appearing in the record, it appears that both the suit and the counterclaim are purely civil in nature, and there is no bar to try both the suit and the counterclaim by this court. Therefore, both the suit and the counterclaim are well maintainable in the eye of law or in form. The plaint reveals sufficient cause of action for the plaintiff for bringing the instant suit, considering the allegation that the defendant is still occupying the suit premises wrongfully even after revocation of license. The counterclaim reveals sufficient cause of action for the defendant for bringing the instant counterclaim, considering the allegation that the plaintiff, in spite of receiving rupees 90,000, did not execute the deed of reconveyance. Accordingly, both these issues are decided in favor of both of the plaintiff and the defendant. Now, let issue number 3 and 4. These issues were, my lord, that whether the plaintiff is the owner of the suit property, whether the defendant is the owner of the suit property. Both these issues are taken up together for the sake of brevity and convenience. The issue is to be decided who is the owner of the suit property. Plaintiff claims that he is the owner. To substantiate his claim, he has adduced his original registered deed of sale, marked herein as Exhibit 1, original LR record of rights marked as Exhibit 3, and original Khajna receipts marked as Exhibit 4, 4/1, and 4/2, from which it appears that the plaintiff purchased the suit property from the defendant and he is the present owner and occupier of the suit property. Moreover, it is admitted question, as it appears from the written statement and the deposition of the DW1, that the defendant put her signature over the said deed of sale. According to my lord, after section 101 has been quoted, my lord. Thereafter, my lord, if no evidence is given by the party on whom burden is passed, the issue must be found against him. In this case, the plaintiff has discharged his burden by producing the above said documents. Now the defendant submits that she is an illiterate person and her signature was obtained fraudulently on the said deed, giving her an impression that the said deed is a loan agreement, and as she asked for a loan of rupees 67,000 from the plaintiff. According to the principles of Indian Evidence Act, since the plaintiff has discharged his burden, the onus of proof has shifted to the defendant to prove that her signature was obtained fraudulently on the said deed of sale. If no evidence is given by the defendant on whom burden is passed, the issue must be found against him. In this suit, the defendant did not adduce any evidence from which court can come to the conclusion that the signature was obtained fraudulently. Moreover, the DW2 in his cross-examination admitted that he is not claiming ownership but claiming possession over the suit property. Already in 2006, Bombay 174, the Honorable Court observed that the registered sale deed carries presumption of genuineness in terms of Section 114 of the Indian Evidence Act 1872, and the burden to prove that it is not genuine lies on the person who alleges that it is not so. In view of the above discussion and considering the other materials on record, the court is constant to hold that the alleged deed of sale dated 25th of May 2001 was rightly executed by the defendant, and the same is valid, legal, and binding. Accordingly, only the plaintiff is the owner of the suit property.
Aditya LCR. Yes, you carry on.
Accordingly, issue number 3 is decided in favor of the plaintiff and issue number 4 is decided as against the defendant. Issue number 5. The defendant in this case the defendant in this case stated that she is not a licensee but the owner. Ownership of the plaintiff is proved in the earlier issues. Now onus of proof is shifted to the defendant to prove that he is an owner and not a licensee. If he fails to prove so, the decree will go in favor of the plaintiff. The defendant in his cross-examination admitted that she received the notice dated 10th of January 2008 for revocation of license. But against the notice, no reply letter was communicated to the plaintiff as it appears from the record. Therefore, the court may presume that the defendant is a licensee, considering the principle silence implies consent. In view of the above discussion, the court is of the considered view that the defendant is a licensee under the plaintiff. Accordingly, this issue is decided in favor of the plaintiff. After all, issue number 6 and 7, both these issues are taken up together for the sake of brevity and convenience. This is a suit for eviction of licensee. It is settled law that to revoke a license, it is not necessary to send any notice to the licensee, but mere intention to determine the license is enough. In Raghupati Roy versus Debu Kormokar, reported at AIR 1956, Calcutta 79, the Honorable High Court at Calcutta held that institution of the suit amounts to an act showing intention to determine license. In this case, the intention is determined. The license is already communicated to the defendant by acceptance of the notice of revocation of license by the defendant. In view of the discussion made here and above, the court is constant to hold that the plaintiff was proved his original prayers. On the contrary, the defendant has failed to prove his counterclaim. Accordingly, I decide the suit in favor of the plaintiff. Keeping in consideration of all the material documents to this suit and hearing of the learned advocates, I have no hesitation to hold that the suit is liable to be decreed and the counterclaim is liable to be dismissed. Hence, it is ordered that the suit be and the same is decreed on contest in favor of the plaintiff and the counterclaim of the defendant is dismissed on contest as against the defendant. Plaintiff does get a decree for eviction and recovery of khas possession of the defendant from the suit premises as described in the schedule of the plaint. The defendant and the men and agents are directed to vacate the suit premises described in the schedule of the plaint and hand over the peaceful vacant possession of the same to the plaintiff within 90 days from the date of passing of this order, failing which the plaintiff is at liberty to evict the defendant in terms of. My lord, the counterclaim as well as my lord, my suit has been decided on merits. Thereafter, my lord, a single appeal was filed by the defendant before the learned district judge. My lord, kindly comes to my lord, page 13. My lord, can page 20. Page 20, my lord, from where my lord the appeal judgment my lord is starting. I will not read, my lord. Not required, my lord. 20, my lord, are the grounds, my lord. 22, my lord, after the case of the plaintiff has been again reiterated. And 24, my lord, case of the appellant has been reiterated. My lord, kindly comes directly to my lord, page 27. Lord, points for determination. The court will have to see one, whether the impugned judgment and decree passed by the learned trial court has any impropriety, irregularity, and illegality or not. Two, whether the learned trial court erred in law or in fact in decreeing of the suit in favor of the plaintiff. A decision with reasons. The argument advanced by the learned advocate for the appellant defendant. The learned advocate for the appellant defendant submitted that in the trial court he filed written statement denying all material allegations against the plaintiff filed by the plaintiff with a counterclaim and prayed for declaration A, that the alleged deed is not out sale and the same is loan on substance. B, decree for direction to reconveyance, execute a deed in favor of the defendant, and C, any other relief or release which your honor may deem fit and proper. For the learned trial court, without framing any specific and proper issues regarding this, has decided this suit against the defendant. He further submitted that the learned trial court framed 8 issues. Out of that, one issue is whether the defendant is the owner of the suit property, and another is licensee as prayed for, and other relief or release is the plaintiff. But no proper issues have been framed in respect of the counterclaim filed by the defendant. He further submitted that the counterclaim of the defendant shall be treated as a counter suit, as that has required to be elaborate discussion about all the issues framed in the counterclaim. But here till the learned trial court did not frame any issues in respect of the counterclaim of the defendant. No proper elaborate discussion is made by the learned trial court in this judgment. In the counterclaim, he raised a point that this is not the out and out sale, and there is no whisper about the judgment about the loan in substance by the defendant in his judgment. Therefore, the appeal should be allowed and the judgment should be set aside. A submission advanced by the learned advocate for the respondent plaintiff. The learned advocate appearing on behalf of the respondent plaintiff supported the judgment passed by the learned trial court. So kindly comes to next page, my lord. The learned advocate for the respondent submitted that the learned trial court properly and elaborately discussed the issues framed by him in this case. He further submitted that in a cross suit, no separate appeal is filed by the defendant against the judgment and decree passed in the cross suit. This point was taken well. Here the appeal is filed against one of the decree. The appeal is not maintainable and the same will be barred by principle of res judicata under section 11 of CPC and prays for dismissal of the appeal. I have gone through the judgment in toto and find that the learned trial court did not frame proper issues in respect of the counterclaim of the defendant, which is treated as the cross suit, nor elaborately discussed about the case made out in the counterclaim by the defendant. No separate judgment has been passed by the learned trial court in respect of the counterclaim of the defendant, which is treated as cross suit. He only made observation that I have no hesitation to hold that the suit is liable to be decreed and the counterclaim is liable to be dismissed. In proper discussion was made, no proper issues were framed by the learned trial court in respect of the counterclaim by the defendant, which is required in law. Therefore, I think that the judgment and decree passed by the learned trial court is not according to law and is required to be set aside. In view of my above discussion and observation, my considered view is that the learned trial court correctly decreed the suit in favor of the plaintiff. Correctly decreed the suit, my lord, in favor of the plaintiff. And I find no impropriety, irregularity, and illegality in the judgment passed by the learned trial court. And he erred both in law and, my lord, fact in decreeing the suit in favor of the plaintiff. Right? It says, my lord, at the first stage, my lord, correctly decreed, no impropriety, no irregularity, and no illegality. And thereafter it says that he erred both in law and fact in decreeing the suit in favor of the plaintiff. And also dismissed the counterclaim of the defendant. Therefore, there is every scope to spill ink in the judgment passed by the learned trial court. My further opinion is that the suit should be remanded back to the learned trial court for fresh trial. Thereafter, kindly see, my lord, hence it is ordered the title appeal number 100 of 2016 be and the same is allowed on contest without any order as to cost. The impugned judgment and decree dated 30th April 2016 passed by the learned civil judge, Junior Division 7th Court, Havda, in connection with title suit number. This is hereby set aside. The suit being title suit number 19 of 2008 is hereby dismissed on contest without any cause. My suit has been dismissed also. Let the judgment and decree passed by the learned trial court set aside and remand another to the trial court for fresh trial after proper framing the issues in respect of the counterclaim filed by the defendant in his written statement and after taking proper evidence if required and discussing elaborately. The learned trial court is further discussed. So, my lord, this second appeal was filed, my lord, and it was admitted.
Have you given the
Kindly comes to page 50,
question of
page 52. my lord.
page 52?
Though, my lord, I do not.
What are
I
the
was not.
questions formulated?
I was not required to, my lord, serve, my lord, prior to, my lord, admission, but the honorable division was, my lord, thrice directed me to serve and it was served. That is why, my lord, started with, my lord, that the respondent has been served but is not represented. It is understandable that the respondent would choose to be away. Page 54 are the, my lord, questions of law. Several questions of substance arise, particularly in the light of the abysmal treatment of the matter by the first appellate court. The more important questions are set out. Could the judgment of the trial court have been set aside without any discussion thereon in the appellate judgment? Could the merits of the plaintiff's case have been prejudiced merely for the perceived inadequate consideration of the cross objection? 3. What is the legal effect of a claim being allowed without much discussion on the cross objection when the cross objection itself is a counter to the claim, in the sense that if the claim is allowed, the cross objection would not survive? 4. Could the suit have been dismissed and the matter sent on remand by the first appellate court? 5. Does the appellate order imply that the plaintiff's claim could no longer be proceeded with, but the counterclaim only survives for fresh consideration? 6. Could the plaintiff's claim have been rejected without reference to the same or any discussion on the evidence or the treatment thereof by the trial court? Thereafter, my lord, this is.
That's fine, no. You just tell me on one point, what about exhibit A? How it was admitted into evidence?
Exhibit, my lord, their document, my lord.
Hmm,
That agreement, my lord. Kindly see, firstly, my lord, we have denied this agreement. And we have denied, my lord, even the signatures. My lord, this agreement,
where was it confronted with when your client was adducing evidence?
my lord,
How it was admitted? That is the point. Was she confronted with the document? It was on your admission. You admitted the signature. Exhibit A. And now read the content.
my lord. Yes, this is my signature, my lord. That
This is my
Yes.
signature, exhibit
the
A.
agreement dated, yes.
And
Let it be
exhibit A.
marked as, yes.
Yes, and
As the signature was admitted, but it was marked.
exhibit A
Yes.
is kind of undertaking given by your client
my lord.
that out of 1,10,000, I have received 90. Upon receipt of rest 20,000, I shall execute the deed of reconveyance.
My lord is going to the document, my lord. That
Yes,
document,
yes.
not a copy of that.
That's why I told my.
But again, that
Paper
will be of
books.
no help to you.
No, that's why I told my lord, paper book is incomplete.
No, that's fine. Documents
That's
are there.
why.
Documents are there.
Yes.
Even this declaration is there.
No,
It doesn't
I'm not telling,
indicate
I'm not
that
telling on
she
merit,
doesn't
but-
have the title.
No,
You can file a suit for specific performance of
Yes,
contract or
yes.
whatever. But anyway,
Wherever. There is one, my lord, confusion which I find, my lord.
yes,
I'm, my lord, finding there are two agreements dates. One, my lord, is 14 September 2001,
yes.
but my lord will find in the evidence page that its signature in the agreement dated 14 September 2003. Why, my
2003.
lord, I'm harping on it? Because, my lord,
No, where is the agreement dated 14 September 2000?
in my, my lord, written statement against the counterclaim,
Hmm.
may I go through their counterclaim? 14 September 2000.
First of all,
Yes, they have also said 14 September 2001
may I indicate this? 14 September 2001 was the agreement.
for sale.
And no, not for sale. Agreement to reconveyance.
Where is
Against
that?
1,10,000. It
Where
was
is
not
that?
exhibited.
where is that agreement?
It was not exhibited. The only exhibit document is that 2003.
There is one photocopy.
Yes.
There is one photocopy. Where is the original?
Original must be with the clients, or with my clients or his clients.
No,
The only exhibit document is that signature and with that acknowledgement. In terms of that 2001 agreement.
When the deed was registered
it was, my lord,
2001.
25th of May 2001.
and when this agreement was executed,
2001.
14 September 2001. It's coming, my lord, thereafter.
but 58C says otherwise.
Yes.
It should be in the same transaction. You are executing the deed of transfer, deed of sale, and there will be execution of agreement for reconveyance.
No, actually, in terms of fact, after execution registering the Alice deed, by which they are claiming that they are the owner. After that, when the respondent in this appeal think that the deed was actually, it was a mortgage deed, but they have signed in a sale deed. Then, in terms of a negotiation took place between the parties.
That is not your case.
Yes.
You have not pleaded that.
No, in my WS, it is stated that in terms of negotiation, one agreement was
Do you
executed
have transfer of property act with you?
in 2001.
Do you have transfer of property? Go through section 58. I'm giving you the book, or if you can download. এটা দিয়ে দেন তো। Read 58C. Read aloud for all of us. 58C.
Mortgage by conditional sale. Where the
That is your case.
yes.
Now,
Where the mortgager ostensibly sells the mortgage property on condition that on default of payment of mortgage money on a certain date, the sale shall become absolute, or on condition that on such payment being made, the sale shall become void, or on condition that on such payment being made by the buyer shall transfer the property to the seller. The transaction is called mortgage by conditional sale, and mortgagee by conditional sale, provided that no such transaction shall be deemed to be a mortgage unless the condition is embodied in a document which affects the purpose to effect the sale.
so either it shall be inside the recital of the deed, sale deed, or the judgment says it can be in a separate agreement but contemporaneous. Where is that document?
That subsequent document,
That agreement,
2001 agreement.
2001 agreement. It should be.
A photocopy with me,
No.
but it was not exhibited.
That is point number one, and even that is not contemporaneous.
Yes.
It was executed sometime quite a couple of months after the execution of deed.
Yes.
May, September.
It is a separate document. But fact,
You can maintain a suit for specific performance of that contract, but it will not inure to your benefit in this case.
But at that time, in 2001, the specific suit for specific purpose they have not preferred. They filed a WS, and on that basis of document, they have filed.
And even technically speaking, it is not counterclaim. Where is the court fees? You
My lord-
haven't paid court fees.
My lord, it was accepted as a counterclaim by the court below, trial court, and by this honorable court, when admission at the time of admission, point number 3, it was stated. It is stated that what is the legal effect of the claim being allowed without much discussion on the cross objection, when the cross objection itself a counter to the claim. In that sense, that if the claim is allowed, cross objection would not survive. That means if whenever we file a WS before denying denial of all the statements of plaint, we generally make out our case in the WS. In that case, they prefer that as a counterclaim. That is the fact. And the trial court held the counterclaim and the suit as a composite nature, passed that composite decree. So my document is one document that my lordship has taken out, that exhibit A. Nothing else. Without that document, I have no exhibited document in this suit. And a proved document.
Now,
It is an admitted document.
the second hurdle, section 11.
Section 11. Well, for section 11, I cannot say anything except that the decree is passed as composite on the whole. And my appeal, my memorandum appeal, stated that in first paragraph of memorandum appeal, it is an appeal on a decree passed on the whole, as taken the plaint and counterclaim as a whole. That's why I preferred a single appeal.
Is it maintainable?
My lord,
You
that is-
have
that
to
is-
you have to file a distinct
my
appeal.
lord, I can place before your lordship what is the matter. I can place some judgments. Thereafter, I cannot go beyond the law, beyond the rule.
And even the counterclaim, my lord, on the face of it seems to be barred by limitation.
Counterclaim
I have filed the suit in the year 2008.
2008.
2008. So if we will go by the September 2001 document,
Well, actually, but it was not taken.
3
in the-
years. And even if we will see cancellation, they were known
Declaration
about
for,
this deed, that's admitted.
declaration for 3 years.
3 years.
That
My lord,
is there.
8 years after I filed the suit, they have never replied to my letter. My lord, even of the, my lord, that agreement September 2001, but I have denied the receipt
Advise
of
your client at least refund the money.
If everything is
but-
okay, my claim is something like that. Exhibit A.
I have
Nothing
denied
else.
the receipt of those payments.
No, you have admitted the signature.
My lord,
It's
the-
better. Ask her to be civil enough to refund the money. She is enjoying the land. It's
No, it's
fine.
admittedly we are in possession.
You are in possession
yes, that's why I filed the suit.
for your eviction.
Eviction and recovery of possession. Not as stated as recovery of possession, but first possession of the property.
The payments were denied, my lord. That-
What else? Give me the judgments.
And I have judgments on
Do you have anything more to say?
No, if required, I'll just hand over copy of some judgment. I don't think I need to, my lord, say on that.
moreover the original sale deed, I think is undervalued. 67,000 for 2 cutters in the year 2000.
This point of facts, my lord, cannot be now. my lord.
I cannot. I just indicate.
She is taking the baton for the state now. You are depriving the state. Take it, Dorothy. Heard Mr. Animesh Paul, learned counsel for the appellant, and Mr. Roy Choudhury, learned counsel for the respondent. Hearing is concluded. Reserved for judgment. একটা সেন্টেন্স লিখে একবার পড়বেন, সেন্টেন্স কমপ্লিট হচ্ছে না, কি লিখছেন বুঝতে পারছি না।
I just
একদম
hand over the
ছটফট করে
copy of subsection 11.
উইথ কপি টু ইয়োর ফ্রেন্ড। Just indicate that it is coming from your end
Okay, and with the case number.
with the case number.
I'll also do that.
Yes, call the next one.
For the app.
I'm going to respond, my lord.
Say,
My lord, I have gone through the report. The another LCR has come, but 7SF, some pages are missing in that LCR. And my lord, one thing more, there is a defect in both two appeals, my lord.
you are the decree holder.
Yes, my lord.
You are the decree holder.
Decree holder.
Let the execution proceeding be stayed, then we will.
Yes,
keep
my
on-
lord, it is already been stayed and
There was an interim order.
Interim order.
That is required to be extended.
yes, my lord.
And
Extended till disposal of the appeal.
Yes, my lord, and more so that we does not have filed any execution case in regard to execute the decree.
Yes,
We does not have filed any execution case.
there is no execution case.
No, my lord.
if there is no execution case, generally, blood, we seek an injunction restraining blood the degree holder from
Yes.
putting the degree to execution. But that was an order.
In this case, my lord, the appellant does not reside in the property, so it does.
শুনানি করবি না?
No, no, no.
কেন? তো একটা date fix করে
হ্যাঁ।
শেষ করে দেবো আমরা।
My lord, kindly fix a date.
Don't do this, I am telling you. Huge number of cases are pending. Don't
But
try
I'll be
to
very
afford
short.
the luxury.
But I'll be
Just-
very short, blood,
yes.
by argument.
Come
I'll be very
prepared.
pointed in my argument.
Behave as an officer of the court. Come prepared. Suggest me a date when you will be comfortable.
My lord, after first week of August.
After first week of August. এতদিন paper book হয়ে গেছে তো। Okay, kindly gives it not on last week of July, blood.
My lord, kindly in the
Any
first.
time, blood, that
of August.
suits your lordship, blood, I'll not be taking much time. Because I'll be very focused on my argument. And the point is very short. My learned friend also knows, blood. Of the allotment made by the Refugee Rehabilitation Department.
Yes, yes, between the
But
siblings.
yes,
Whether for the family or
Yes,
for
or-
the
or-
allotee. That is the
that is
question.
the point.
In that point, both the.
Don't either you assist
My
the
lord.
court right now or don't waste your time. Suggest a date.
My lord, in the first week of
No.
August.
এই দেখি কবে লাস্ট আমি আদিত্য কোথায় গেলেন? Best date would have been 21st of July anyway.
But
Come on,
21st of July, blood, I am.
You have no issue.
I
My
don't
lord,
have any.
Are you
kindly
going to
2
join?
weeks accommodation, my lord? My lord, kindly 2 weeks accommodation.
No. 31st of July. Having heard learned counsel representing the parties, the matter is adjourned to appear on 31st of July under the heading hearing. The order is peremptory.
The interim order may be
Aye,
extended. blood.
interim order shall renew till that date. Let it be till that date. I hope on 31st we can take up the appeal. দেখি পরেরটা দেখুন।
Agreed. Okay, ready for you now?
Yes, sir.
Appearing on behalf of the petitioners.
Yes,
Mr. Tanmay Mukherjee is appearing on behalf of the petitioners, my lord. He is on his legs in court number 5. I'm praying for a short passover.
Lord, I am with the opposite party. They are more instance one of today is the fixed.
so he is seeking passover. I am passing over the matter, say till 12. Thereafter, if Mr. Mukherjee cannot make it, I will dispose it of. Don't worry. Just remind me at 12. If in the meantime he doesn't turn up. পরেরটা দিন।
I am appearing on behalf of the opposite party, my lord, led by Mr. Ayon Banerjee, my lord. Appearing for the petitioners, my lord. I'm seeking an
an adjournment for the day, for the
Why?
week, your lordship.
Why?
Lordship, it's a change brief, your lordship.
When did you receive the brief?
Lordship, it was a change brief.
When did you accept?
Lordship is in 2019, your lordship. There
You
was
accepted the brief in
Yes, Your Lordship.
2019.
Yes, your
And
lordship.
we are,
No, your lordship. Lordship, recently I'm not being able to contact the petitioner, my client, your
are
lordship.
you Miss Mukherjee? Who is Akanksha Mukherjee?
Last occasion, she appeared and
Lordship,
she is
last,
the advocate on record.
I am the advocate on record, your lordship.
Last occasion, she was not present and the
Lordship, I filed my wakalatnama way back in 2019. There was a dismiss for default because the brief was not given to me yet. Lordship, I filed for restoration.
You are Miss Majumdar.
Yes, your lordship. Lordship, I filed for restoration.
Restoration application is pending.
Yes,
the
your lordship.
last occasion, the last.
Since 2019, the restoration is pending.
Because the last, the honorable
Why?
judges was.
Lordship, Lordship, the last occasion, the
Why
matter,
it should be restored?
Lordship, the last occasion, the matter that the matter appeared.
Why it should be restored? Is there any merit?
Lordship, because when the matter was dismissed for default, the brief was not with me.
So
The previous
you took
advocate-
the responsibility, you filed the wakalatnama. If you do that
after.
without the brief,
That was after, your lordship.
then tell me why it should be restored.
Because when it was dismissed for default, I did not receive the wakalatnama yet. The previous
Who
advocate,
was it?
the previous advocate had given an NOC. The petitioner was looking for an advocate, and once,
Then let your petitioner suffer.
your lordship, the petitioner should not suffer.
Either you assess me on merit. Why should it be restored? Is there any merit in your application? What is the order impugn?
It's there with the restoration application. Oh, lordship, the order impugned. Lordship, the Lordship, the order impugned is on the ground of urban land ceiling not applicable, section 8 of the West Bengal Land Reforms Act not applicable where the urban land ceiling applies. Lordship, that point is anyway not valid anymore, your lordship.
Very well, madam. Suggested it, but the condition is you have to satisfy me on the merit of your application, then only it will be
Lordship,
suggested.
lordship, anytime next week, your lordship.
Anytime next week,
Lordship, let it be next Wednesday.
20. Suggest a date
Yes, your lordship.
when you will be comfortable, and on that day just forget the adjournment.
Lordship, 26.
লিখুন। Upon hearing Ms. Majumdar, learned counsel for the petitioner, and Ms. Dhamali for the opposite party, the matter is adjourned to appear on 26th of July under the heading hearing.
Lordship, may kindly restore the application.
Precondition. You have to show me there is merit. Both the applications will be taken up together and disposed of. I will restore surely, but I won't leave any room for you to get the matter dismissed for default further.
Lordship,
So come back on 26th.
oblige.
Call the next one. that arbitration award. Why it was adjourned the other day? Oh, service, there is something with service, no?
The service has been complete, directed me to file an evidence service. Not evidence service, going to ready today. In course of today, I filed the evidence service. But on the last occasion, your lordship asked me the interest calculation. That is the our degree 1,79,000 that has been deposited in the and the interest 12% per annum from 15th May to 1995 to calculating 31st June 2023.
এই আদিত্য একটু জিপি অফিসে কাউকে ডাকুন তো, গভর্নমেন্ট প্লিডার। Notice has been served, no?
Notice
Your claim is against the state only.
state airport authority.
No, airport authority represented by CPWD or PWD?
No, airport authority is separate wings. I asked the authority to envelope is returned.
How it could be returned? NSCBI is very much there. Every day, hundreds of flights are taken off. Senior manager civil. But the senior manager civil is not a party. You have filed this execution proceeding against executive engineer civil, airport division 3.
He also be
And you were sending notice to senior manager civil.
yes, executive engineer civil airport.
No such designation in this address.
Senior manager to both are parties. Executive engineer also party and also senior manager engineer engineering civil airport authority also being party. And I sought to both the parties responded.
The airport authority must be coming under the Ministry of Civil Aviation.
Yes.
Then it must be under the control of central government.
Maybe sharp upon the.
We have office of ASG and deputy ASG. So many persons are there.
If your lordship directed me to sharp notice.
Look, problem is if I pass any order,
Yes.
then again they will come and they will say, please reopen, let us have our say. Once for all, let us decide the issue.
If your lordship directed me to serve the senior advocate of the central government, 11 number standard, I will be.
Who is there? Do you know anyone appearing representing central government in High Court? Any of your friends? None. Ashwanta. Better you serve and come,
Yes.
otherwise
Created another problem.
yes, it will create another problem. But you have to, presuming that your affidavit of service is with me, I am passing the order.
Yes.
So it should be in my record. Heard Mr. De, affidavit of service suggests that envelope addressed to the receiver absent addressed to the Senior Manager Civil Airport Authority of India, NSCBI, has returned as receiver was absent, and the other envelope addressed to Executive Engineer returned with the endorsement no such designation in this address. ওটা ইনভার্টেড কমার মধ্যে রাখুন, no such designation মানে কি জানি না in this address. Stop. Under such circumstances, petitioner is directed to serve notice upon the council representing the central government as airport authority comes under the Ministry of Civil Aviation. Let the matter be adjourned to appear on 31st of July. You take this, Mr. Day, file it along with your affidavit.
আমি তো এভিডেন্স সার্ভিস করে দিয়ে যাই তারপর
Huh? It is governed under the old act.
ওল্ড
Then for it to begin. দেখি 14 কি হচ্ছে, এটা পাসওয়ার্ড করে থাক। Gaji means that gentleman, no? With beard. I am passing it over. দেখি পরেরটা।
Fixing lordship, I make to appear on behalf of the appellant. Delay application, 125 days delay.
How many days delay?
125 days.
125 days. How
How
you have
the-
dealt with the delay?
Paragraph number 3, 4 and 5. You are obtaining the certified copy of the order from the court below.
What is the suit for?
Suit for declaration and permanent injunction. Status quo order is under challenge before your honorable court.
Status quo order.
Till the disposal of the suit, status quo was granted, and only the particular dag number 2309. This dag has been recorded in my favor, my client. So they have been obtained the order of injunction from the court below. When I am not cultivating the land, entering into the land.
When did you file the application for condonation of delay?
File this application, my lord, the,
It was also belated,
it was, after, my lord, the division bench, my lord,
detected that there was.
detected the report that you have not filed a section 5, they have just filed that. That is, my lord, can 2. It was filed on, my lord, 15/6/2023.
Yes,
My lord, kindly consider paragraph 3 of the application for condonation of delay. It is stated that your petitioner states that due to his inability, it is the case that the person who have affirmed this application, he was physically handicapped. And it has been stated in paragraph 2 that he is the person who is looking after the cases before the learned trial court. Now, paragraph 3 states that your petitioner states that due to his inability, he could not contact his learned advocate below, before the court below, and he came to the knowledge when your petitioner went to the suit plot for cultivation at the time of the the plaintiff was obstructed to enter into his plot of land. So, learned court before obtaining certified copy on 1/2/2023. So it is their case that the averment, as per the averment, it is only when they have went to the suit property, they came to know. But kindly consider the order under challenge. It is a contested order. They have filed a written objection. Moreover, the person who have affirmed, Kamakha Charan Ghosh, apart from that, Mohadev Ghosh, the appellant petitioner number 1, he has affirmed every application before the learned trial court, including the written objection.
it's order 43 appeal. So
Order 43.
order 43
Yeah.
appeal. Let him proceed.
My lord, what is there? There is status quo order. Everybody,
No.
whoever is in
You pay. You have to pay cost. You pay and contest marriage.
my lord, the delay, my lord, 125 days, my lord.
I will be pronouncing an order.
Last explanation of the how many that 125 days delay they are claiming, no proper explanation has been given.
Which is why it is to be compensated by money value.
Properly not, my lord, these are asking for
There is no-
properly not explained. My
Yes.
lord, in case of the, my lord, anybody can affirm this affidavit. His case of I have filed an affidavit
that
for the
you
court
were-
below, then I have to face a.
That you were not in a position to move. You were ailing. Where is that document? In High Court, you have taken these applications as a very easygoing matter.
And say section for section 5 application, we are not such a strict nature which have filed before
That
the
is the
court
whole
below.
trouble.
My lord,
Now go through the judgment of Honorable Justice Deepak Mishra, you will get to know how to deal with these applications. Since we are taking lenient view, doesn't mean you are absolved from making out your case properly.
but
Don't claim it as a matter of right.
no matter.
I
this
will
not-
come and take out an application consisting of 6-7 sentences, and that will oblige the court to condone your delay. That cannot be. How many petitioners?
petitioners, my lord, there is the three.
Three. What about other two?
Other two, my lord, they are the busy in the cultivation.
Where is that averment? About the omission or inaction on the part of others?
They are
We don't take any pedantic view. That doesn't mean you won't give proper explanation.
But all of them, my lord, that they are
party to the proceeding. One
So
of
but-
them came before this court and.
Now,
for
why
this-
the delay? Why the delay? You are citing the inaction of one gentleman. What about the two others?
My lord, they are somehow busy, other.
It is to be presumed.
Busy.
Since you were absent about their conduct, so it is to be presumed they are awfully busy. They cannot.
But
do
only
anything.
the ground obtaining the certificate. There is no other ground that I am not coming to the court. My lord, when my lord the obstructed at the time.
Where is the averment? If you go on arguing, I will ask you this question. Where is the averment? There is no proper explanation. So it should be rejected with liberty to file afresh. Go.
As your lordship.
The matter, we don't take it in that pedantic manner, doesn't give you the leverage to come before the court with any kind of excuses. That is my point. So you pay. You are cultivated.
Cultivated. Well, the handicapped.
Borgad, handicap.
Handicap. My client is handicapped person.
Praying for vacating
Then
of
why
the
this,
injunction
why
order.
this luxury status quo to be maintained? What's the prejudice in it?
Well, status
Go
quo.
and fight out this suit.
No, before the court below we are fighting, but status quo that till the disposal, this is my difficulty. I till the disposal of the suit.
Temporary injunction.
Dispose of with finally, but till the disposal of the suit.
11/8, the order was passed. 31/8, 2022. 20 days after, they have filed an application praying for cultivation of the permission to cultivating the
This
land.
is interim order,
No, finally disposal.
Final-
Final order.
temporary order. The
Temporary.
temporary injunction should be like that till the disposal of suit. Interim till the disposal of application, temporary till the disposal of suit. That is the usual order.
Somebody,
your
I
client can-
am prejudiced by this order. Otherwise, I cannot.
If your client can afford the luxury to challenge this kind of order before this court, then he should be asked to pay some money to go and pay to district legal service authority or state legal services authority.
Such a poor person you are asking.
4%.
There are already orders of cost upon my learned friend's client.
My lord,
Trial court.
trial court, they are asking for one after one application for execution for the, I've been going to the enter into the land, they have filed the application for police or like that, directing the Rayana police station to protect that. This
You
is the,
are Bargadar.
I'm the not the I'm the owner of the land. My land has been recorded, particularly 2309. Their petitioners are in interest, they have gifted the property to me. My lord, I have been, my lord, the cultivating that they are claiming they are the partition, but they are a shareholder of this plot. These are one of the conflicting of the parties.
This application is for condonation of delay of 125 days in preparing the appeal. Stop. Out of I produced the application which reflects the equable attitude and laid back ball of nerves of the petitioners. Since this is an appeal against order, since this is an appeal against order, having considered the narratives of the petitioner, I am inclined to condone the delay of 125 days subject to payment of cost of rupees 15. Cost of rupees 5,000 as suggested
I
by,
say 2000, my lord, take me at 2000.
as suggested by ওটা লেখা দরকার নেই।
2000.
Can 2 of 2023 is as disposed of. Then, yes, your friend has come.
Yes.
Then, what is the what is the item number?
7.
7. Then to এখানে ওখানে করে দিন তুমি আদিত্য বাবুকে বলুন কোথায় এই cost of rupees 5,000 to be paid within 2 weeks from date. এরপরে তো আর ওখানে চলে যাবে আমাদের কাছে লেটজি হ্যাঁ record be placed before the appropriate bench. Yes,
No, no, I'm for the preemptive.
preemptive
Yes. Petitioner before your lordship.
under 8.
Under section 8 of the West Bengal Land.
What's the issue?
But here,
Something different from the issue considered by the larger bench.
Lord, I say that this issue is still pending before the larger bench. Why, Lord, I shall not satisfy before your lordship.
No, if it is pending, then
Lord, I will have to show that before your lordship
Yes.
that it's pending. Lord, merely Lord, from the bar, Lord, I should not. Lord, I shall not show before your lordship. This is not the preemption application is being filed. If your lordship once takes it up, page 17 of the revisional application.
why this section 6? Why this paper was filed? 6 of the Estate Acquisition Act, showing how the property was retained and
But in 77, this application was being filed. Lord, if your lordship takes it
Yes,
up, Lord, there
page-
page 17, Lord, 70.
17. Yes,
Lord, your lordship will get the property details at Lord paragraph 1. I will not trouble your lordship
Hmm.
regarding that. Lord, kindly takes up paragraph 4, Lord, at page 18. প্রতিপক্ষ বিক্রেতা, has your lordship got it, Lord? গত ইংরাজি 13/12/76 তারিখে এক ক্রেতা রেজিস্ট্রিকৃত কোবালা মূলে ক্রয়ের এক তপশিল বর্ণিত জমি প্রতিপক্ষ বিক্রেতাকে 4,000 টাকা পণ মূল্যে বিক্রয় করিয়াছেন প্রকাশে প্রতিপক্ষ ক্রেতা 8/3/77 তারিখে উক্ত ক্রয়ের এক তপশিল বর্ণিত সম্পত্তির দলিল করিতে আসিলে ছাত্রগণ তদ্দিবসে সর্বপ্রথমে উক্ত দিবসে খরিদ বিক্রয়ের কথা অবগত হইতে পারিয়া গত ইংরাজি 8/3/77 তারিখে উক্ত প্রতিপক্ষর ক্রেতা নামীয় কোবালা দলিলের নকল গ্রহণ করিয়া সবশেষ অবগত হইয়া প্রতিপক্ষ বিক্রেতাগণ প্রতিপক্ষ ক্রেতাকে 4,000 টাকা পণে বিক্রয় করিয়াছেন। Thereafter, the consideration amount and 10% interest. ছায়েল ক্ষয়ের এক, not paragraph, next paragraph. ছায়েল ক্ষয়ের এক তপশিল বর্ণিত জমি ও ক্রয়ের এক তপশিল বর্ণিত জমি লাগোয়া পশ্চিম দিকে অবস্থিত হইতেছে এবং ক্ষয়ের এক তপশিল বর্ণিত জমির পূর্ব দিকে ক্রয়ের এক তপশিল বর্ণিত জমি হইতেছে। ছায়েলের উক্ত জমি উক্ত ক্রয়ের এক তপশিল জমির লংগেস্ট কমন বাউন্ডারি হইতেছে, সে কারণে ছায়েলগণ such and such ভিসিনেজের তপশিল বর্ণিত জমি ওয়েস্ট বেঙ্গল ল্যান্ড রিফর্মস অ্যাক্টের 8 ধারায় বিধান মতে প্রিএমশন মূলে পাইতে হকদার হইয়াছে। So, it's an application by an adjoining owner, not claiming to be the longest boundary line.
yes.
Now, your lordship knows, if on that day, if your lordship has marked the date of the deed, that is on 8th of March 1977. But I am carrying the deeds with me. ভালো কপি একটা দিন। But their knowledge is of 8th of March 1977.
Yes.
The deed was being executed on 13th December 1976. Milord, the Tarapodo Ghosh, Milord, is the Milord, owner, Milord, who has Milord sold out the property by virtue of this deed. Milord, on that very day, if your lordship takes up Milord these two deeds side by side, on that very day, what happened?
Have
This
you annexed?
Tarapodo,
Have you annexed
Milord,
copy
no.
of the deed?
Copy of the
No.
deed is not being annexed, not part of the revisional application. But the thing remains, it's an admitted position. Tarapodo, by virtue of two deeds, on a single day, have transferred his entire property, his entire share, in respect of two different persons. One of shell is being preempted by my learned friend. Now, this is no more racing. This honorable court has held. If a person by a single day, by virtue of two transactions, has transferred his entire share to different person, then it has to be taken into a single transaction. And since the entire share is being transferred, no preemption right is maintainable. And regarding whether entire share preemption right is maintainable or not, larger bench is pending. I am relying on this unreported judgment, only 2-3 paragraphs. If your lordship takes it up.
In this case, two issues.
Kindly takes up the point formulated in paragraph number 30, Roman 2. But if your lordship consider the Roman 2, your lordship will read this is the point involved.
Yes.
Now, this answer of this point is given in paragraph number 49 to 51. It's an affirmative, and here the preemption application was got dismissed by this honorable. Paragraph 49 to 51, this answer to that point, point number 2.
Yes.
If your lordship consider these two deeds, even my case is better, because on that day two deed was being executed by the original owner. My deed is the last one. So by virtue of this deed, ultimately this person is holding out entire share, whatever he is having in respect of that plot of land. And this honorable court held that even if it is a two transaction, it has to be assumed that it has a single transaction and the person is holding his entire share in that holding. So the preemption right is not met.
You have to wait.
Page
Yes.
41, the entire share, both the court hold, the Borodakanto did not transfer
No,
the
sir.
entire plot.
Because one
Entire
deed is being
plot,
considered.
the Kanailal had 5 decimals. Years of Borodakanto transferred 7 decimal out of 8 decimals.
But
it did not share entire plot.
no, two
Out of
deeds
the
have not
7
been
decimal out of 8.
What he is submitting, according to Mr. Mukherjee, this gentleman, your vendor, executed two deeds.
Yes, on the same day.
And on the same date, he transferred his entire share to two different persons maybe,
Yes.
but on the same day by executing two different deeds, which according to Honorable Coordinate Bench of this court should be considered as the transfer of entire share. And then again, importing the analogy that when entire share in the plot is transferred, you cannot invoke section 8 of the WBLR Act. That point is now being considered before the larger
Larger
bench.
bench, that is
So
constituted.
let's wait for some days, let it be decided.
But in this our case is his vendor did not share the entire plot.
No, on
But
the same day. What happened?
Go through the deed.
He is asking for preemption against the transfer in favor of Shudhin Chandra. Now, on the same day,
the vendor, my lord, original owner have also transferred by virtue of a separate deed on the same day to Bihari also. So by virtue of
Thus,
Bihari is not a petitioner before your
yes,
lordship.
right. What he is on is by transferring the entire property to two different persons on the identical date
No, no.
by two different
My lord,
instruments.
he is arguing, my lord, but in this case, but I purchase in a two different date. I purchase certain portion in respect of certain times, my lord, long before my lord his purchase 3 years, and certain portion, my lord, at that time. But two preemption case. As such, my lord, he is arguing, my lord, that two deeds is in a same date. But this is not a, my lord,
That
case,
is not
our
his,
case.
that is not his case. What he is saying, whatever area of land the gentleman had, he transferred the property to two different persons on the same day.
No, my lord, he is total, he is co-sharer, my lord, in total land, my lord, 42 decimals. My lord, my lord, he is vendor, my lord, 21 decimals. My lord, his vendor's right is 21 decimals. My lord, in 21 decimals, my lord, already in a part 21 decibel, out of 21 decibels, my lord, I purchased long before his purchase. And my lord, in 21 decibels, my lord, his vendor and my vendor purchased a deed in a same day, my lord, as such. But my lord, I file a preemption application on the basis of the purchase earlier. But this is not a case.
My learned friend couldn't not understand not what I not wanted to apprise before you. He is correct. The entire land is 21 decimal.
42 decibel.
Out of 21, my client, the original vendor, who have transferred, he do have only 6 decimal. Out of these two deeds, 3.5 and 3.5 on a single day is being transferred in favor of Sudhi and in favor of Bihari. So the original owner lost his interest.
You were challenging the transfer in favor of Sudhi.
Yes, my lord.
No,
Yes,
according to the opposite party, who is challenging your application, that remaining part, whatever was the area, was transferred by two instruments on a same day to two different persons. Thereby, entire share, whatever the gentleman had, was transferred. So, Section 8 cannot be invoked. That is what Mr. Mukherjee is saying. Now, this issue is being considered by the larger bench. So, let's wait for some more days. Hearing is going on.
As per the matter is pending till site 77.
Because if ultimately this honorable court holds that even if the entire share of a co-sharer is being transferred and preemption application is still maintainable, I will be out of court.
We are not deciding the application itself.
No, yes, yes, but the earlier in that issue, already in an earlier division bench,
that is Thanara relying upon. This honorable court, this judgment
now this matter is being again reconsidered by the larger bench, and what I was given to understand, that bench has sought for placing the matter to a higher bench comprising of at least 3 honorable judges.
Because there are diverse views, even I am one of the matter is.
Are you appearing?
Yes, one of the matter is tagged over there. This honorable court is not facing difficulties since there are various division bench
matters also.
Yes. Now, but one matter, learned judge, honorable judge, Horiston director held that the Kinkor Mahato entire share is not a good law, and that matter was challenged before the Supreme Court. Supreme Court dismissed this.
But that is SMP dismissal is not marked.
Yes, yes. But
unless it is decided on merit,
yes,
there will be no merger.
Yes, but
so it remains.
SLP will dismiss.
And it's been dismissed on merit.
Even the last matter when went to a Supreme Court said, I will not decide you for some larger bench.
No, we used to dispose of application under Section 8 in the light of the judgment taken by Justice Bhattacharya. Entire share transfer, go. No preemption.
No preemption.
Now, because diverse opinion.
Yes,
let's wait for a couple of days. You have been
start Kinkor Mahato in 2005. Kinkor Mahato.
Also. Hard. Oh, Mukherjee is calling Mukherjee.
Yes.
heard Mr. Tanmoy Mukherjee, learned counsel for the petitioner, and Mr. Kishore Mukherjee for the opposite party. It is submitted that the vendor on same day transferred his entire share by executing two different deeds. Now the question that crops up is whether the transfer of entire share would debar the petitioner from taking recourse to Section 8 of the West Bengal Land Reforms Act, and the issue is being considered by the larger bench. Under such circumstances, I am adjourning it sine die with liberty to mention. Matter is adjourned sine die. Under such circumstances, matter is adjourned sine die with liberty to mention. But Mr. Mukherjee, may I keep this?
Definitely.
Let it be with me.
Definitely. I'm extremely grateful. What kind of CO number? Just CO number.
CO number 1793 of 2018 by Honorable Justice Sabyasachi Bhattacharya.
Great.
Yes. Call the next one.
Number 12.
Tanmoy Mukherjee, Kishore Mukherjee. Koi 12 dekh. Huh? Not today, for today.
Copy.
Look.
Item number 17.
Yes, your application for condonation of delay is allowed subject to payment of cost of rupees 15,000 to be paid within a week. Call the next one. Eighteen. Huh? Can 1 of 2019.
Item number 18.
Ashwin. None is appearing on behalf of the petitioner. Then Robin Thapa. The revisional application assails the order number 71 dated 20th September 2014, passed by learned third judge, Presidency Small Causes Court, Calcutta, in Miss Case number 56 of 2014. By the impugned order, learned trial court was pleased to reject the prayer of the petitioner decree holder for a direction upon the no, sorry, ওটা উল্টো হবে prayer for petitioner now opposite party landlady for a direction upon the petitioner to pay occupational charges on the ground that without adjudicating the application under Order 21 Rule 101 of the Civil Procedure Code and thereby determining the status of the petitioners, no such direction could be given as the judgment of Honorable Apex Court speaks of the obligation of the tenant to pay occupational charges even in the execution proceeding. Stop. The averment made in the petition filed by Devika Mitro Lipika De and Lipika De in the proceeding under Order 21 Rule 101 of the Code of Civil Procedure demonstrate that they are claiming tenancy right over the suit property. Stop. It is a specific case that their mother Hashi Das was the original tenant, and after her demise, they inherited the tenancy right. Stop. Therefore, learned trial court appears to have committed jurisdictional error in rejecting the application. Stop. When the petitioners in the proceeding under Order 21 Rule 101 of the Code of Civil Procedure is seeking direction claiming to be the legal heirs of original tenant, learned trial court ought to have allowed the prayer for occupational charges filed by the landlady opposite party in the proceeding before the learned trial court. Stop. the order impugned, comma, as I have already indicated, suffers from jurisdictional error and is set aside. Jurisdictional error and is set aside. Learned trial court is directed to readmit the application for direction upon the petitioners of miss case number 56 of 2014 to pay occupational charges and dispose of the same according to law. The revisional application is thus disposed of. A copy of the order be sent to. Yes, call the next one. একটা application আছে না 4010 হয়তো 4010 কোথায় অ্যাপ্লিকেশনটা ফেলে রেখে পাচ্ছে না তাহলে কি করবো কিসের অ্যাপিল লিখুন The matter was adjourned on 19th of June and 27th of June in absence of learned counsel for the appellant. Today is also appellant is not represented. The conduct of the appellant demonstrates a lack of interest, her lack of interest to proceed with the appeal. The appeal is dismissed for default with cost of rupees 5,000 CP. Yes.
Lord, Mr. Chakraborty is leading me in his answer the petition. Lord, kindly this matter be fixed at 2 p.m.
At 2 p.m. Why?
Lord, Mr. Chakraborty is busy in another phone.
Who is Mr. Chakraborty? Which
Shamal
Chakraborty? Shamal Chakraborty. He is appearing on behalf of opposite party. You take note. Then.
But here also, my lord, I am appearing on behalf of the preemptee petitioner. But in this case, my lord, also,
Same condition.
no, my lord, no, not, but here also the point in respect of the special bench are there. But then even, my lord, in my respect to submission, my lord, this application can be disposed of by your lordship. Why, my lord, may I first show your lordship, it's my duty to point out why, my lord, the points are pending as per me. My lord, if your lordship, my lord, comes to their preemption application, it starts with page 14 of the revisional application, my lord. Has your lordship got it, my lord? If your lordship turns over to page 16, my lord, once looks at paragraph 6. Though in the record of rights, it's not only Pukur, my lord, the other is Dhosha and others recording of their classification. But the preemption application, the preemptor claim, it's a part of Bastu. Now, that's why I say, my lord, whether Bastu preemption is maintainable or not, that point is pending. If your lordship turns over to, my lord, page 18 of my written objection, point number 6, your lordship will get, my lord, specifically I have pleaded the entire holding is being transferred. So this is also, my lord, the point is pending before the larger bench. But still, my lord, I say that this revisional application can be disposed of. Why, my lord? If your lordship once looks at paragraph 2 of his preemption application, my lord, at page 14 of the revisional application. I'm sorry, my lord, I'm troubling your lordship.
No, it's okay.
My lord, we get point number 2 and 3. It's important. নিম্নের তপশিলে বর্ণিত ভূমি সহ উক্ত সাচ দাগের মোট ভূমি সহ জোতের অন্যান্য ভূমি দরখাস্তকারীর পিতা ও পিতার ভাতার পুত্র সর্বেশ্বরের নামিত সমাংশের সত্ত্বীয় দখলি সম্পত্তি ছিল এবং গত ইংরাজি জমিদারি আইন গ্রহণ অনুসারে জরিপের উক্তভাবে রেকর্ড হইয়া চূড়ান্ত প্রচারিত হইয়াছে. Similar, these are the two original owner in respect of the entire holding. Next paragraph is important. গত ইংরাজি 23/5/57 তারিখে সম্পাদিত ও গত ইংরাজি সাচ তারিখে রেজিস্ট্রিকৃত অংশ বন্টন মূলে দরখাস্তকারীর পিতা নালিশি 185 খতিয়ানে সাচ দাগের উত্তরাংশের 23 ডেসিমালের মধ্যে পূর্বাংশের 21 ডেসিমাল ভূমি সহ অন্য কতক সম্পদ ভূমি নিজ অংশে প্রাপ্ত হন। দরখাস্তকারীর পিতা অংশ বন্টনের ক তপশিল বর্ণিত স্থান প্রাপ্ত হইয়া তাহাতে সত্যবান ও দখলিকার থাকাকালে তাহার অংশপ্রাপ্ত ভূমি সম্বন্ধে গত ইংরাজি সাচ তারিখে সম্পাদিত ও গত ইংরাজি সাচ তারিখে রেজিস্ট্রিকৃত একখণ্ড নিরূপণ দলিল মূলে নালিশি খতিয়ানের 106 নম্বর দাগের 13 ডেসিমালের 99 দাগের 12 ডেসিমালের সাচ সরজমিনে পশ্চিমাংশে 97 দাগের পূর্বাংশে সাচ ভূমি সহ অন্যান্য কতক ভূমি দরখাস্তকারীকে thereafter my description, if your lordship skip 3 lines, 8 decimal, has your lordship got 8 decimal ভূমি সহ অন্যান্য কতক ভূমি দরখাস্তকারীর ভাতা অমরেন্দ্রনাথ পড়িয়াকে নিরূপণ করিয়া তাহাদের অনুকূলে সত্য দখল ও ত্যাগ করেন. Now, my lord, thereafter, so my lord, your lordship will get, my lord, if I pause here for a moment. So your lordship will get initially the property in respect of 2 co-sharers. They have amicably partitioned the property. After the partition, my lord, 2 blocks is being created. And thereafter, my lord, in respect of one of the block, my lord, the original vendor transferred to my client. But, my lord, interestingly, the preemption application is being prayed for on 2-fold ground. Though it has been spelled out that yes, there is a partition, but still he said, no, I am a co-sharer and as well as adjoining owner. So, my lord, these 2 flow, my lord, both the courts found, my lord, he is not a co-sharer, but he is an adjoining co-owner. Now, my lord, the law is now settled, my lord, your lordship knows the language of, my lord, I will show before your lordship where my lord, both the courts found that. My lord, if your lordship takes up the trial court judgments first, it starts with page 22. Well, kindly takes up page 25.
Here, my lord, the partition, deed of partition is being considered, my lord,
Yes,
exhibit 2 and
exhibit 2.
exhibit 2A.
Hmm.
And thereafter, my lord, the next page also, it has been found, my lord, by virtue of exhibit 2 and 2A, he is not a co-sharer. And ultimately, my lord, the preemption application is being allowed only on the ground of adjoining.
Yes.
My lord, the appellate court give a specific finding that he is not a co-sharer. May I take your lordship to that finding? If your lordship straight away comes to page 41, the portion, my lord, where the appellate court found.
Hmm.
My lord, internal page 7 of the judgment.
Yes.
17 lines from the bottom. My lord, the sentence starts with there is nothing.
There is nothing.
Yes,
on
there
record.
is nothing on record to show that the opposite party is a co-sharer in respect of the land, or he is a land adjoining to the case land. On the other hand, the petitioner has been able to discharge his ownership that he has been possessing the land adjoining to the case land. It is specifically mentioned in the claim that the case property belongs to Amod Korea, is a part of the case holding. There is no material that the case property has been partitioned in between the property meets and bounds. Material and evidence on record specifically shows that the present petitioner are possessing the land adjoining the case land. As such, the petitioner are entitled to get preemption of the case land in view of section 8(1) of the West Bengal Land Reforms Act. Considering the facts and circumstances, having regard to the materials of evidence of LCR, I am satisfied to hold that the finding of the learned civil judge is quite justified, and consequently I find no reason to interfere with the same as a result. So, my lord, ultimately both the court found, my lord, he is a co-share, my lord, he is a adjoining court.
Adjoining.
Now, my lord, the opening language of the section 8, if we take it up, if a share or portion of a plot of a land of a riot is being transferred to any person other than a co-share. So this sentence is being not explained by this honorable court in various judgments. And ultimately the interpretation is given that there has to be, there are three compartments. One is co-sharer, another is borgadar, and the last one is the adjoining court. This honorable court interpreted section 8 saying that when the opening language of the section suggests that the property has to be transferred by a co-sharer to a person other than a co-sharer, then and then only the right of preemption opens. So the existence of a co-sharer in a plot of land has to be there. Otherwise, the preemption right will not open. But here in the present case, there is no existence of a co-sharer as per their own case. And both the court has negated their right of co-sharership. The right in respect of only adjoining owner is being granted. There is no challenge by them, no cross appeal, nor even before this honorable court. So they have acceded so far as regards rejection of their prayer on the ground of co-sharership is concerned. Now, my lord, I will not cite the latest one because in the 2014 judgment, the previous judgment was being considered by this honorable court. But the Honorable Justice Torun Kumar Gupta, as his lordship then was, I had an opportunity to appear in this kind of matter. But if your lordship kindly once looks at the 2014 volume 1, Calcutta High Court notes, Calcutta page 706. The head note, may I read first? If a common owner transfers specific portion out of the entire plot with defined areas and boundaries to different purchasers, then those purchasers do not become co-sharer in respect of the other, even though respective proportionate share with reference to the entire jama was noted in their respective deeds held. In the instant case also, the common owner sold specific earmark defined portion to the preemptor and the preemptee's vendor. Hence, preemptors was not a co-sharer of the preemptee's vendor. Section 14, its applicability held. Section 14 comes to play, I am not on that. So, here, from the claims your lordship will get, since the common owner have transferred the property by demarcation, So there doesn't exist any case of co-sharership. So my lord, in the present case also, my lord, the right of preemption was being granted on the ground of vicinity. Why not that has been negated, my lord, if your lordship take to now, my lord, kindly takes up paragraph 30 because that part, my lord, I am not troubling. Regarding the partition, it's not necessary since the common owner is transferring demarcated portion. Now, whether the preemption will be maintainable. Paragraph 30. Now, the question is whether the preemptor, Gopal Chandra Mondal, who has admittedly found to be an adjacent landowner of the suit land, can claim preemption on account of transfer of a portion of a land by Shankar Nath Mondal to preemptee being a third party purchaser, though the impugned Kobala dated through the impugned Kobala dated such and such. For the proper appreciation of the argument of the learned counsel on this code, it will be worthy to note the first portion of section 8 of the act, which runs as follows. But I'm not troubling, your lordship has already seen it. In the case of such and such Shupra, a question arose as to whether an adjoining landowner can exercise the right of preemption in case of a transfer of a portion of a holding while there was no co-sharer in the said holding. It was answered in negative with the following observation. This judgment also I am carrying. In view of the expression any person other than a co-sharer, the section contemplates that the holding must be held under joint ownership and not under the ownership of a single individual. This is also apparent from the first proviso of section 8 subsection 1 of the act, which provides that a co-sharer right will have preferential right as against a contiguous tenant to have such portion or share of the holding transferred to him. Where both of them are applicants at the same time, the section restricts the owner's unfettered right of sale and contemplates him to sell the share or portion of the holding either to his co-sharer or to his contiguous tenant, as the case may be. It is now an accepted legal principle that where the provision of a statute providing for right of preemption equals to the freedom of transfer, the same should be strictly construed, and unless a case of strictly within the provision, claim of preemption should not be allowed. Section 8(1) of the Act entrusted the light of the aforesaid legal principle leaves no room of doubt that the holding, a share or portion of which is transferred, must be held under joint ownership. The contention of Mr. Bhuya that even though there is no co-sharer of the holding, the contiguous right has a right of preemption in case of a transfer of a share of a portion of a holding is overruled. It has noted that at the relevant time, the term holding was not replaced by the word plot of a land of a riot. Such proposition is mutated mutandis applicable in the instant case of transfer of a portion or share of a plot of land of a riot to any person when there was no co-sharer in respect of the plot of land. The co-sharer of a riot in a plot of land has been defined under section such and such, but I am not troubling your lordship regarding that portion. Now, my lord, if your lordship takes up paragraph 20, on a plain reading, that has your lordship. On a plain reading of subsection 4 of section 5 of the Act of 1955, it is clear that in case of a transfer of portion or share of such a plot of land by one of which the provision of preemption under section 8 apply, then notice was required to be issued to all the co-sharer of the said plot of land who are not parties to the transfer, and also for affixing a copy thereof on different places mentioned therein. It is thus palpable that if there is no co-sharer in the plot of land, there is no question of issuing any notice under section 5(4), as well as the existence of any right of preemption by anybody. It is already been established that the preemptor Gopal Chandra Mondal was not a co-sharer of the land of Shankar Nath Mondal, and that there was no co-sharer in respect of the land of Shankar Nath Mondal. If that be the position, then preemptor Gopal Chandra Mondal cannot exercise the right of preemption under section 8 of 1955, even though he was an adjacent landowner of the plot of land, a portion of which has been sold by the Shankar Nath Mondal to the petitioner preemptee by co-validated such and such. So, here also, the case is exactly the same. He was not found to be a co-sharer, but was a adjoining co-owner. But opening language of section 8 is being interpreted. There are other two judgments which has been relied by this. I am carrying those two also. You can act. 77 CW. Yes, Milord, I'm referring, Milord, I'm not citing formally. 77 CWL, page 272. Same proposition, Milord, the quotation is being quoted, Milord, in the paragraph. So, Milord, this is the proposition by virtue of which, Milord, respectfully I am submitting, though the point is involved in the special bench regarding the entire share, since here also the entire share is being transferred, and though, Milord, it's a plot which has been claimed to be a Bastu or adjacent to the Bastu by the preemptor himself, which is also pending before the larger bench. Milord, in my respectful submission, if your lordship is at par with me, Milord, in my respectful submission, that since there was no existence of co-sharer as per the decision of both the courts, which has not been assailed by them. So, Milord, this preemption application is liable to be dismissed on this score also. And if your lordship is not with me, Milord, in this point, then Milord, we will have to wait for the larger bench.
Let Mr. Chakraborty come back.
Yes.
At 2 PM, my lord.
I shall pass order. So anytime when he feels comfortable, it will not be adjourned. That is the thing.
But what today say, my lord? He's busy in 23, my lord.
Yes, ask him to appear at 2. I shall be here till 3.
Yes, sir.
Anytime till 3.
Sure.
Otherwise, I shall take the record to my chamber and dictate the order.
Sure, my lord. Right.
Since, Milord, the case made out in the preemption is that there was an amicable partition by a registered deed. So, Milord, community of interest cannot remain there.
Yes. Let Mr. Chakraborty
Yes,
come. Let's see.
I'm so good. Great.
আরে তো এটা দুটোর সময় আবার যখন আসবে। Call the next one. Twenty-three, 24. গুচ্ছের পিটিশন করে রেখে দিয়েছে। আচ্ছা, এটা তো কন্টেম্পট অ্যাপ্লিকেশনটা। হ্যাঁ, অরিজিনালটা কই? মূল পিটিশনটা কই? দিস সিপিএম। লিখে দিন। As usual, none is appearing on behalf of the petition. I do not find any reason to adjourn the matter so moto. The matter stands dismissed for default with cost of rupees 5,000. না কন্টেম্পটা রয়েছে না, দেখি ওটা। এইবার করবো কি? ওটা দেখুন তো ডিসপোজ অফ হয়ে গেছে কিনা। ওটা কেন লিস্টে আছে? ওটা তো থাকার কথা না। আপনি খালি সিভিল রিভিশন গুলো করুন। 23 ডিসপোজ করে দিন। LCRB send down. देखिए 25 दिन LC send out. Then Ashwin, since the matter is appearing almost after 4 years, I am inclined to adjourn the matter to appear on 31st of July. 4 years. Munisher পরে then same order. Madam, 31st July. একই order করে দিন। Next.
Your Lordship, I am appealing for the petition, Your Lordship.
For the petitioner.
Yes.
Yes.
Your Lordship, Mr. Shahnaz Tariq Minait appearing, Your Lordship. He is on his legs in courtroom number 18. I have been instructed to pay for not today, Your Lordship.
Ashwin, what is your good name?
Pratik Sardar, Your Lordship.
Pratik
Sardar.
Sardar. Are you aware of the direction of Justice Basu in this matter?
Lordship, no.
No. Do you know anything about this application?
No, Your Lordship.
Yes, in view of the order dated 15th of July 2019, passed by the coordinate bench, let the matter go out of list. Identical issue is being considered by the larger bench. This is an application under Section 8, so it will not be taken up. Call the next one. देखो। With liberty to mention ওটা লিখে দিও না এক কাজ করুন এটা পরপর ডেকে দিন 35 অবধি
In item number 35, my lord, I am for the petitioner. This is my application.
My lord, Mr. Ranjan Shah is appearing for the opposite party. I'm late by Mr. Ranjan Shah. My lord, I got to know, my lord, my client has been died and I could not get the information and the death certificate and the particulars.
Your client, subject to correction, there are more than one opposite parties. Who is dead? Who is dead? You are referring to item number 35.
Yes,
35,
my
my
lord.
lord. There are two petitioners, my lord.
Shanti
Thapa,
Thapa
yes, my
and
lord.
another.
Yes.
Now, who is dead?
Only one party
Only
is
one
there.
party.
Only
There's
Shanti
Shanti
Thapa is
Thapa,
there.
only one party, my lord.
Oh, the list is showing otherwise. Let me go through
Only
the,
one
let me go
opposite
through the
party.
petition.
And my lord,
List is indicating Shanti Thapa and another.
but in cost.
Shanti
settlement,
Thapa
only
alone
one-
is the opposite
Only
person.
one.
You used to represent Shanti Thapa.
Yes, my lord. I'm led by Mr. Ranjan Shah is appearing in court number 17, my lords.
Today, my lord, there are two applications. One is condonation
Now-
of delay and one is, my lord, restoration, my lord. There are two
What
applications.
about substitution?
My lord, I could not get the
My lord,
information.
let the main application be restored, my lord. Thereafter,
My lord-
they will provide me the names of the legal heirs and I shall substitute the.
Before filing the substitution, these three petition,
Now, technically speaking, this application doesn't exist in the eye of law. It has been dismissed for default. Now that they have come before the court for restoration. Unless the matter is restored, how they can take step for substitution?
my lord. My lord, but my lord, in the petition, my lord, in this condonation of delay petition, that is can 3, my lord, here is no mention of the the time period of the delay, my lord. The time period which has been the exact time period of the delay, my lord.
Time period of?
Of the proper
Delay, my lord.
the time period, how many delays?
No, we are not considering the,
Due to the COVID period, madam, I have mentioned there, the date of dismissal was on 13th of September 2019. My
Very
lord, date of knowledge is 4th of November 2019. Thereafter, my lord, we have taken steps, my lord, and I am the Air Force Department of Union of India, my lord. There, it took some days, my lord, and there is a delay of.
What was the period of protection given by Honorable Apex Court during this COVID time?
My lord, this was lockdown was from 18th March 2020
till
and
February?
till February 22, my lord.
22.
So my application was filed. Application was filed in 25th November 2020.
2020
itself. So, my lord, there is a delay of 6 months delay, my lord, in filing the application due to this pandemic period, my lord. And none appears, my lord. Nobody appears. On that day, matter was, kindly see the page 8, my lord. Order dated 13th of September. None appears on behalf of the party on the matter is called on. CO number is dismissed for default.
13th of September, date of dismissal. You filed this application on 11th of October.
At 25th October 2020, next year, man, almost
11th October 2020.
almost 25th November 2020.
25th November 2020.
20.
Very well. 25th
Almost
November.
6 months delay, man.
And
I have said, my lord, in paragraph 13, 14, my lord. Actually, date of knowledge was in November, 4th November 19, my lord. Thereafter, due to this COVID period, starts, my lord, from March, nothing happened, my lord. Then after 6 months, when the things are become normal, thereafter, the application was taken out and filed. Initial 6 months were very hard, my lord. So everything was stopped there.
My lord, my lord, kindly may be permitted to file.
yes, you are permitted. Have your
affidavit
say.
in opposition, my lord.
Affidavit in opposition. When did you file?
Kindly be permitted to file the.
You want to file?
Yes, my lord.
I saw already.
Then morally you should not oppose this prayer for condonation of delay. Very well, you come back with your affidavit in opposition.
So already.
Let your young friend, yes, when suggested it.
May I summon, my lord?
Why you are looking so scary? Be at ease. Am I looking like a demon? Don't be nervous. Yes.
Ma'am, let the main application store thereafter the main application. Because this is the requirement for restoration. So let the application be concerned. Then you give me the name of legal year, then the main application will be substituted.
Yes, ma'am.
Otherwise, that will be pending. So if
Sir,
you
it
see
is substitute, it is substitute.
that will be in the CO number. That will be in the CO number. These two can be disposed of. If you want, can be disposed of. Yes, you give your consent.
I'm adjourning the matter for a week. Let your friend be comfortable and let her come back
Yes, ma'am.
after a week.
Hello, madam.
Just look at her face.
She understood.
Why you were so unnerved? Be steady. What's your good name?
Kita Shah.
Ankita Shah. Be steady. 1 week time will do.
Yes.
Yeah, madam. Are you Mr. Dhar?
Yes, madam. No, madam, I'm Sunil Singhania. I'm Sunil Singhania.
Okay. Heard Mr. Singhania, learned counsel for the petitioner. Assisted by, yes, what is your name? Kaur. Assisted by Miss Kaur and Miss
Ankita Shah.
Shah for the opposite party. Stop. Miss Shah wants to come back with affidavit in opposition.
With
To the
instruction,
petition.
my lord. No, my lord, kindly. With instruction.
With instruction.
With instruction.
Let her file opposition.
My
now.
lord,
How
it
does-
will delay the matter. My main, I want to proceed with the main
It
application.
doesn't go well with you, Mr. Singhani.
Yes,
You were responsible for the delay.
my lord.
Don't take it otherwise.
ma'am.
So let her come back.
My lord.
I won't allow you any time unless you show your courageous face. Why you were so nervous? You were an advocate. So yes. Matter is urgent to appear on 31st of July. Parties are at liberty to exchange their pleadings in the meantime. Beforehand, you shall supply the copy.
Please, my lord, direction may be given to give me a copy of civil revision application.
Revisional
Because
application.
I do not have the main application, my lord.
But you are the petitioner.
But my lord, fortunately, my lord, the filed by some earlier advocate, my lord.
No, you have challenged the order of learned additional district judge, setting aside the order of eviction. So you are the petitioner. How could she give you copy?
I should pay the cost, my lord, because the main application is misplaced by some earlier
Oh.
erstwhile advocate, my lord.
If you have the copy of the application, please provide one.
Yes.
Mr. Chakraborty, are you ready?
Back to that, not subjected. I tender my unqualified evidence, Lord, item number 32 to 34. Lord, I could not address your lordship because, Lord, I was in court number 652.
Still survive? I don't know. Ajay, then wait for a while. It's a parted matter. Let me finish it.
No, division কিন্তু দুটো করে matter. 20 items.
Next matter. It's a second appeal.
Yes.
It is my appeal. I should be praying for not this, having some difficulty. I shall be hardly at.
Who is appearing for the respondent?
We have served, we have served the notice, but I'm praying just not this week. I'm because I'll be out of station for next week.
Very well.
Yes.
একটু নোট রাখুন, এটা যদি ডাকা হয় বলবেন। Yes.
37. Good.
My lord, my application under section 8
has been allowed by both by the trial court as well as by the appellate court. My lord, all
On the ground of vicinage.
my lord, yes, my lord, all the points which has been canvassed by the petitioner hearing has been addressed and considered by both the courts, my lord. My lord, I'm reading,
Including the point that in absence of any co-sharer, you can maintain the application under section 8. That is the crux.
in absence of co-sharer.
The property was partitioned
Yes,
and you have acquired the share of one of the persons after partition. So with the factum of partition, the co-sharership goes.
no, my lord, since the present petitioner purchased the property, being a stranger, I therefore applied for preemption. So co-sharer question, but nobody else.
Now, when you can seek preemption under section 8,
My lord, section 8, my lord,
do you have the book? Where is land reform
my
act?
lord, first of all, co-sharer. Second, my lord, adjust.
First of all, the property should be what?
Property should be, my lord,
Joint property. There should be co-sharers in respect of the property transferred.
in case, my lord, suppose, my lord, I am not a co-sharer. I suppose,
I'm not talking about you.
yes,
Suppose your junior friend is the absolute owner.
yes,
He transferred the property to your other friend sitting on the left side.
yes,
Entire share is transferred. There is no co-sharer.
yes.
Can you resist such transfer under section 8?
My lord,
Had there been two persons and one of them is transferring, then you are competent to challenge it under section 8. In absence of any co-sharership, can you maintain any application under
my lord,
section 8?
here,
That
my
is the
lord,
question.
here, that point has also been taken into consideration.
How?
My lord, I'm showing,
Yes, yes.
that portion, it is a holding is my lord, the joint holding, it has been held.
No,
Joint,
sir.
joint.
Subject to correction. Come
My
to
lord,
that.
suppose, my lord, besides that, my lord, if I am,
You are the adjoining co-owner.
I don't remember.
There is no dispute.
No dispute.
The question is whether you can cross the threshold as the property was not a co-sharership property or joint property.
My lord,
That is the question.
no, my lord, if somebody who is not my co-sharer, he is holding land adjacent to my property, and that property is, my lord, sold to somebody else without, but not to me. Whether I can file the.
That is the question.
Yes, well, I can definitely. My lord,
No, how? Show me.
well, I am saying.
Yes.
Well,
First, let's read
my
the
lord,
provision.
X plot.
Mr. Chakraborty, first read the provision of section 8.
Yes.
There is no harm. Then let us proceed.
Yes. My lord, this is the right of purchase by co-sharer or contiguous tenant. That is, or has been.
No, by co-sharer or contiguous tenant. No.
So.
No, you read.
If a portion or a share of a plot of land of a riot is transferred to any person other than a co-sharer of a riot in the plot of land, the Borgadar in the plot of land.
Mr. Chakraborty,
may.
There lies the question. If a portion or share of a property is transferred other than to a co-sharer.
Yes.
If there is no co-sharer, then what would happen? Can you invoke section 8? That is the question only.
Yes, my lord. Yes.
That subject to correction. Perhaps you can.
I am a Borgadar. Question of co-sharership does not arise.
Your right to cultivate will remain, but you cannot claim under section 8 in absence of any co-sharer.
I am an adjacent owner.
You cannot unless there is a co-sharer. Please read it again.
If a portion or share of a plot of land of a riot is transferred to any person other than a co-sharer of the
So
riot.
please stop here.
Yes.
That is the crucial element other than co-sharer. In absence of any co-sharer, can you maintain?
Let us read the whole.
Okay, very good.
Transferred to a person other than a co-sharer or a riot in the plot of land. The borgadar in the plot of land may within 3 months of the date of such transfer or my lord, any co-sharer of a right in a plot of land may within 3 months of the service of the notice of section 5 or any riot.
Absolutely, there is
Possessing land. If
there is no dispute, Mr. Chakraborty. The question is, in absence of any co-sharer, can you maintain any application?
Yes, my lord. Or
again, you are saying yes.
My lord, yes, I say yes because if each and every clause has been connected with the
Fine,
word.
but when? If without transferring it to a co-sharer, it is sold to someone else. Please remember.
Or any riot possessing land, any riot possessing land adjoining such plot of land. Suppose I am a riot, I am not a co-sharer. I am a riot. I am not a co-sharer.
Let me clear my position.
Yes.
The section says, if a plot of land is transferred to anyone, to a stranger, without transferring it to the co-sharer or without notifying the co-sharer,
yes,
then first borgadar, then the co-sharer, then the adjacent landowner can maintain an application. But when there is no co-sharer,
this here starts from my right starts from
your right cannot start in absence of any co-sharer. Please understand.
Can you see? My right starts from here also, even if I am not a co-sharer, or any riot possessing land adjoining to such plot of land.
Sir, before
may within 4 months.
Before entering into the room, there shall be a threshold which you need to cross. And here the threshold is co-sharer.
When the word adjoining land has been used.
Absolutely, you are right.
That has got some meaning. So that is irrespective
but
of.
When? Read again. If it is not transferred to a co-sharer, when there is no co-sharer, question of transferring to co-sharer doesn't arise.
According to your lordship, if I am not a co-sharer.
I am not talking about you.
Yes.
If someone wants to transfer any portion of land where there is a co-sharer and without notifying or transferring the land to that co-sharer, if it is transferred to someone else, then the right of borgadar, the co-sharer and the adjoining landowner under section 8 will survive. Otherwise not. That is my point. And that is the section.
My understanding of the section is that, my lord, if a co-sharer is, my lord, not sold.
There has to have a co-sharer.
No, my lord.
In your case, there is no co-sharer.
My lord, it is not invariably necessary that a person who will apply for preemption must be a co-sharer.
I am not saying that, Mr. Chakraborty. Please understand.
Yes.
The property transferred, it should be a joint property. There must be some co-sharer. Otherwise, you cannot invoke section 8. That is the law.
No, that also held here that some other co-sharers are there.
No, sir.
But I shall read the.
Okay, read it.
I shall read the appropriate.
Read it.
I shall read the appropriate.
Okay.
Yes. My lord, the plaintiffs. My lord, appellate court judgment and this.
You are.
My lord,
You are Bono Bihari Paria.
My lord, the petitioner in the case, Bono Bihari Paira. PAI Paira.
Whatever it is. You are the petitioner.
Plaintiff's case in brief is that the suit land along with other lands originally belonged to Maheshwar Paira, the father of the petitioner, and the Sarveshwar Paira in equal share. And
Mr. Chakraborty, may I be excused? Come to page 7. Come to page 7 of the judgment of learned appellate court.
I shall read the relevant
No,
portion.
no, you kindly come to that, then you will come back to your point.
Page 7 means.
Page 7, internal page 7. The judgment of the learned appellate court.
Yes.
That should be somewhere.
Yes, it is. Holding is same holding, let's mention.
Page, internal page 7,
Yes.
page 41 perhaps.
Page 7. It is OP is a co-sharer.
Sir, the sentence begins with, there is nothing on record to show that OP is a co-sharer in the case land or he has whatever. This is the observation of learned first appellate court, and that is the observation of learned trial court as well. They have allowed your application on the ground of vicinage.
He has also stated that he purchased the share of Etato. There is nothing on record to show that OP is a co-sharer in the land.
Yes.
Or OP means my lord purchaser.
You.
The purchaser.
There is no co-sharer. You just go on reading.
My lord, transferor should be a co-sharer. OP is not. My lord, OP is not.
There was no co-sharer
Acha.
in the land. It was
Acha.
partitioned and.
OP is a. There is nothing on record to show that OP is a co-sharer in the case land or has land adjacent to the case land. On the other hand, the petitioner has been able to discharge his owners that he has been possessing the land adjoining to the case land. It is specifically mentioned in the plain that the case property belonged to Amor Koira is part of the case holding. There is no material that the case property has been partitioned in between the co-sharers by mediation bound.
That
Well,
is
this
your case.
your lordship's point comes here.
That is your case, yes. Anyway, you finish. Mr. Chakravarti, better you come back at 2. In the meantime, you go through both the order of learned trial court as well as learned appellate court. Your matter will be taken up at 2. Yes. I matter to the into. Just wait, sir. Just for a minute.
I think only prayer was let it appear as to be mentioned today. And Malheur was pleased to grant.
Yes.
Grant that.
Why it is to be mentioned?
Why? And what is the urgency? This is the only thought point. Whether my lord, kindly see the last order that was passed by my lord. Matter is coming up tomorrow. I have got nothing there. Last paragraph of my lord's order was that an attempt should be made to meet. Now, my lord, with all humility, I submit, my lord, that
yes.
Sorry. I submit, my lord, that it was a responsibility.
Mr. Ghosh, would you please excuse us? We have 6 more minutes to go. Don't interrupt. Yes.
Sorry, my lord. The only prayer was that if one can meet, that's the only reason.
Yes.
Now, today, virtual, physical, I have requested, I have advised my client that if they are not willing to go to Delhi because 3rd week they have to go, the father has to go, you come and meet, but at least you make an attempt so that you are everything said and done.
interest of the child should be, and tomorrow there is also a conciliation meeting before the Alipur court. That is neither here nor there. But important point is, at least since both of them are in Calcutta today, at least in the evening this is the only request. If my learned friend agrees, it's okay. Otherwise, Bharat will take up the matter tomorrow. That's the urgency.
I
because
disagree now, Lord.
because Bharat, the only prayer, because we wanted a time. They said on virtual mode. Then I said virtual mode, it is not possible because half is both of I have told that you must, if they are not going to the, because urgency, and because one thing is admitted, for the last 4 years the daughter was with the mother, and mother has seen the development of the daughter. Now the interest in the mind should be that only. So if they can meet Bharat, that's all. Otherwise, Bharat will take up the matter. But this is the only prayer and this is the urgency. Nothing else. Because
Lord, can I
today,
now
face to
respond?
face.
Where is your plan?
Can I respond, my lord?
Yes, why not?
First, my lord, I am having an objection to the listing of the matter today. A 9:33 is no time to inform the opposite side that we are going to make a mention at 10:30.
Yes.
Point 1. Point 2, beyond that we said we are not available for mentioning. Then you want to mention, no problem. But you bring these facts to the notice of the honorable judge that we have served at 9:33. They have opposed the mentioning, but still I have proceeded with the mentioning. Then, my lord, the ball is in your lordship's court. Point 1. Point 2, your lordships indicated that there should be a meeting, if possible, virtually. I agreed to that meeting virtually. I agreed. Now, after agreeing, they said not 15th July, we want it on 17th July. We said forget 15th July, we'll have it on 17th July. 17th July, after they put it in writing that we are agreeable for a virtual meeting, then after about a couple of hours later, they change again. They say, sorry, now our client is not interested in having a virtual meeting. Let us meet face to face. Now, my lord, we can't act as per their beck and call every time. Once I have agreed for a virtual meeting, my lords, then we proceed with a virtual meeting.
Where is your client?
My client, no, there is no ego, madam. With great respect, there is no ego, and I'm not at all going for any meeting now.
From 15 they are saying they will not.
Yes, I will not go for a meeting now.
Where is your client?
Right now, he's not here. Of course, in Calcutta. But no, please have the matter tomorrow. I'll argue my contempt and can too. Whatever orders are passed, my lord, I will respectfully bow down to those orders. But I will not have a meeting now, my lord, with them. This exercise for past 1.5 years has resulted in nothing, my lord, except wastage of judicial time. There is an order passed in the earlier CO that all attempts for resolution have failed. And yet, my lords, I agreed with my learned friend, but they can't, my lords, pick and choose timings. Then they agree for virtual meeting. Then they say, no. Now, because our client has decided suddenly to travel from Delhi to Calcutta, now your client should also be there for a physical meeting. And lawyers should meet virtually. So, my lord, two people, client, who are fighting tooth and nail on custody, will meet physically. What happens after in that physical meeting, I don't know. Who's going to take responsibility? We don't know. But lawyers will meet virtually. You know how that is possible with respect. This is all on record. I can file that. All emails that are exchanged. So I don't wish to do any meeting, Lord. I will argue my case tomorrow with great respect.
But I reserve my breath today because what the learned senior lawyer has said, my lord, it may not be proper because there was no instance on our side to say we will not meet. In fact, on 15th, they write, if you don't meet, cancel. Now, this attitude with all humility, my lord, is not conducive for the child. And all problems started, my lord, with all humility is when the meeting, because they waited for 1 week. We got this server copy, immediately we wrote. Anyway, be that as it may, this is the position. Today, my client is here. She has come to Calcutta. We are ready to meet. If they don't meet, my lord will take.
No, we are not ready to meet. I am under instructions to state, my lord. I'll argue my case tomorrow.
Yes. Very well.
Yes.
And tomorrow also in Alipur court, there is a mediation.
That is in the divorce case. That has got nothing to do with this.
Very well.
Very well. Should I need to pass any order?
Attempt has been made. My attempt has been made even today. That's the reason why mentioning is made, madam. And supplementary list, madam, has taken up this matter with all humility. I submit, madam. The fact that
matter is taken up as to be mentioned. As to be mentioned. Under the heading to be mentioned. Mr. Roy, learned senior counsel for the opposite party, submits that pursuant to the suggestion given by Mr. Roy in course of hearing on 6th of July, option was given to the parties to meet, if possible, even on virtual mode, to discuss the issue before the petition filed by the petitioner is taken up for petitioner being Can 2 of 23 is taken up for adjudication. Stop. But as a matter of fact, the parties failed to meet either physically or virtually. Though, according to Mr. Roy, his client, Deepika Agarwal, was keen to meet physically.
He is, and she's here today in Calcutta.
And she has come to Calcutta. According to Mr. Gupta, learned counsel for the petitioner, initially parties agreed to meet virtually.
Yes, on 17th July.
On 17th of July. Subsequently, there is a change of mind and the opposite party insisted for a physical meeting. But Mr. Agarwal, the petitioner, is unwilling to meet physically. Under such circumstances, I am not inclined to pass any order. Let the matter appear tomorrow.
Tomorrow, so grateful. We'll argue tomorrow.
Under the same heading.
Deeply obliged.
Come back tomorrow.
We'll argue. We'll argue.
And if possible, find out the office address of Child Welfare Committee.
Deeply obliged.
Then I may have to seek the help of Chairman Child Welfare Committee in the matter. We may even contemplate to take the child in the custody of Welfare Committee or not, because both the parents are yet to grow up. Yes.
Item number.
Come back tomorrow. Item number
32 to 30.
Yes, what is your matter?
Tomorrow 2 p.m.
Where is Mr. Gupta? At 2?
Whatever time suits you. Let's say that in the morning, but first.
No, I have many other matters. Please.
2 p.m.
At 2.
For 12:30.
2 because earlier it was 2 p.m. Subject to
If it is there in the order, it's there.
there in the order,
It's there. Then what's the point of
I
GOP?
will just reconfirm.
Let's go 2 p.m. Then we have to have no opinion.
Yes, come back at 2. Yes, item number 32, 33, 34.
Yes, ma'am. These
Yes.
are all identical issues that
না ও তো আছে ওটা হ্যাঁ
several occasions it was heard. But the petitioner.
Who is opposing Mr. Ghosh?
No, no.
You are the petitioner or opposite party?
But I am appearing on the petitioner in 3 cases.
Very well.
96 now, but his age, but it has been admitted by the earlier court. There is a.
To make it a point to appear tomorrow. Your matter, yes, not today. I am fixing it tomorrow. You
Tomorrow will not subject to any morning or PM or whatever suits your lordship.
আমাদের
Can it be
দুপুরে
at
কি
12
আছে?
o'clock? 2 p.m. I have heard, my lord, it will continue because the quorum between
before
the
2.
parties will continue
Before 2.
before 2.
এটা সকালের দিকে একটু
10:30. 10:30.
The lordship has delivered judgment, but unfortunately I could not come because an item number 1 was taken up at court number 13.
If I can remember correctly, you have lost.
We have lost.
Yes. So
It has been remanded.
no, set aside on the ground that tenancy notice under section 13(6) was extinguished with the surrender of possession and reconstruction of building, and on the ground of promissory estoppel as well. Having promised, I shall withdraw the suit. That is my poor wisdom. Anyway.
My lord, in item 38, though it is appearing as.
Sir,
second-
don't you have wristwatch?
Oh, sorry. It's not trap.
Come at 2. Come at 2. Thank you.
My lord, we must first understand the fact of the case.
Yes.
My lord, kindly see the revision petition itself. My
Revisional application.
Revision application will itself, as well as my application for preemption, will depict and explain that I am co-sharer as well as adjacent owner of the property. My lord, kindly see the revision petition. My lord, that by registered, I am reading, my lord, registered deed of Kovala dated 19 March 79, the petitioner purchased the lands as detailed below from the Amarendranath Paira. My lord, your lordship will find that certain dark numbers are there, no demarcation is there. Originally, the said lands, along with other lands, belong to Maheshwar Paira and Sarveshwar Paira in equal shares. That pursuant to a deed of partition executed on 23rd March 1967 and registered in the 5th June 1957 between Maheshwar Paira and Sarveshwar Paira, the entire plot number such and such situating at Mauja Patna in the district of Midnapur fell in the share of Maheshwar Paira. That is my grandfather. Maheshwar is my grandfather. Thereafter, said Maheshwar Paira executed a deed of Nirupan on 21st of April 1968, which was registered on 10th May 1968 in favor of his two sons. Who are the Devendranath Paira, the predecessor of the opposite parties, and Amarendranath Paira, the vendor of the petitioner. So in between these two brothers, one brother out of the undivided property sold his share to the present petitioner. So, my lord, who is the Amarendra's co-sharer was Devendra, and we are the legal heirs of Devendra. So that hurdle is not there. And it is also reflected in my petition under section 8. My lord, kindly see, I have also page.
You proceed
Yes.
further.
My lord, kindly see the second page of the.
You finish reading the application for revision, then we'll come.
Yes,
to
all right, I'm good. All right. My lord, that by the said registered deed of Nirupon, 0.3 decimal of the land on western portion. Okay, this is also of plot number 97, 4th decimal of plot number 98, 12 decimal of land on the western portion of the plot number 99, and 8 decimal on western portion of the plot number 106, totaling 27 decimals, were allotted to Amarendranath Paira, and the remaining portion, that is undivided, remaining portion of the land being 13 decimal of plot 106, plot number 106, 12 decimals of plot number 99, and 03 decimal of plot number 97, totaling 28 decimals were allotted to Devendranath Paira. That the said Amarendranath Paira by a Kovala executed on 19 March 1979 and registered on 20th March 1979 sold the entire portion of the land as apposite to Rishikesh Ghorui. So, my lord, instead of selling the property to Devendra or the legal heirs of the Devendra, the Amarendra sold it to a stranger, being to the petitioner who has filed this divisional application. The Devendranath Paira, the predecessor of the opposite parties, filed the application. Well, kindly see who has filed the application? Devendranath Paira, The predecessor of the opposite parties herein filed an application before the learned civil judge, Junior Division First Court, Kontai, under Section 8(1) of the West Bengal Land Reform Act for preemption of the land sold to the petitioner on the ground being co-sharer and adjoining, though both co-sharer and adjoining possessing riot, which gave rise to the judicial miscase number 102 of 81. That during the pendency proceedings, said Devendra Paira died and opposite party herein were substituted in his legal heirs, as his legal heirs. The petitioner herein opposed the application for preemption by filing the written objection, especially contending therein as follows: as the entire holding was transferred, the application for preemption was not maintainable, that the applicant not being a co-sharer of the vendor of the purchaser, the application for preemption on the ground that the application is a co-sharer is liable to be dismissed, that the area of the 12 decimal in plot of plot number 9 being pond, the said application is bad in law, that the applicant at present holds land measuring about 40 bighas, as the family of the applicant being more than 40 bighas of landed property, the said application for preemption is liable to be rejected, that the opposite party, the petitioner herein is a Borgadar under the Amarendra Paira and obtain Borga receipts of delivery of bhag produce to the extent of 25%. He is in possession of the suit property after purchase of the same. That the application is barred by limitation. That the learned civil judge, Junior Division First Court, Kontai by the judgment and order date passed on 29 August 1997 allowed the said application on the ground that the petitioner therein are possessing the land adjoining to the case land and thus entitled to the benefit of 8(1) of the West Bengal Land Reforms Act. That the learned judge in disposing of the said application for preemption did not even consider the points raised and urged by the opposite parties therein, as stated in paragraph 9, that the petitioner being aggrieved by the dissatisfied has filed the application. Shall I read the entire? That the learned additional district judge third court, Midnapur, by the judgment and order passed on 31st August, dismissed the misappeal on the finding that the petitioner therein are possessing the land adjoining the land case land, and as such petitioners are entitled to get preemption of the case land in view of.
Chakraborty, just so we have crossed the relevant part.
Yes.
You tell me, what does Nirupan, deed of Nirupan mean?
My lord, deed of Nirupan, my lord, 2 sons, it was given to 2 sons and undivided property. My lord, there he is saying that this eto sotok of dag number, eto sotok of dag, undivided property. So I am the co-sharer. In spite of selling the same, it has been sold to the stranger. And besides that, from the partition deed also, it has been reflected that it is adjoining to my property. Because suppose, my lord, the share of the pond undivided and question of the partition does not arise. Share of the pond or low land is there, undivided property, and at the same time co-share. My lord, kindly see the judgments of both the courts below, my lord, whether all the issues have been addressed or not. Then, my lord, I shall cite also judgment. My friend has cited judgment of Justice Gupta, Tarun Kumar Gupta. I shall also cite judgment to that effect, my lord. My lord, now I am reading because we are on division, because factual aspect is not very much material, my lord, because he has traveled 2 courts already. The miss case arises out of an application under section 8(1). Well, I am reading the trial court's order. Under 8(1) of West Bengal Land Reforms Act. Petitioner's case in brief is that the suit lands along with other land originally belonged to Maheshwar Paira, that is my grandfather, the father of the petitioner, and Sarveshwar Paira in equal shares, and were recorded as such in RS record of right. There was a registered partition on 23rd of May 57 between the Maheshwar and Sarveshwar in respect of the suit plots and entire suit plots number such and such. decimal out of 23 decimals of suit plot number 106 on the eastern portion fell in the share of Maheshwar Paira as a result of the said person. Thereafter, Maheshwar Paira executed a registered deed of Nirupon on 21st of April 68 in favor of the petitioner and the Amorendra, in favor of the petitioner and the Amorendranath Paira. So it is in favor of 2 persons, his brother, and delivered possession of the suit plot in their favor by the said deed of Nirupam, 3 decimal of land, no demarcation, 3 decimal of land on the western portion of the suit plot. So, my lord, the adjacent is coming. Western portion of the suit plot number 97, 4 decimal of suit plot number 98, and 12 decimal of land on the eastern portion. My lord, kindly see this. So adjacent ownership is also coming from the same eastern portion of the suit plot number 99, and 8 decimal on the southern portion of the suit plot number 106 were allotted to Amorendranath Paira, and the remaining portion of the aforesaid, that is undivided, the remaining portion of the aforesaid plot were allotted to the petitioner. So the petitioner is possessing land adjoining to the land transferred, and thus the petitioner is entitled to preempt the case land on the ground of vicinage. Said Amorendranath Paira sold the suit land to the OP by registered Kovala dated 19th March 1979 for a consideration of money of 5,000. No notice of transfer by the said Kovala was served. Well, this is also fulfilling the condition. Served upon the beneficiary, and thus the petitioner has filed the application for preemption of the suit land on the ground of contiguous land owner. The consideration, money, and usual compensation are stated to have been deposited. Entire deposit has been made. Now several judgments have been made that on part deposit application will not be maintainable. But here we have deposited the entire. The original petitioner died during the pendency of the suit, and his legal heirs were substituted in his place. OP has opposed the application for preemption by filing written objection. The case of the opposite party is that the petitioner are not entitled to preempt the case land on the ground of adjoining riot and the co-sharer. The opposite party further alleges that the suit plot were never partitioned. The opposite party further alleges that it is our case, their case. The opposite party further alleges the suit plots were never partitioned. They themselves saying not partitioned. Not partitioned by metes and bounds. So, my lord, this is fulfilling the purpose. Co-sharer and my lord, unpartitioned, undivided property, and he is sold to a stranger. And I have deposited the entire money and made the application within time. Further, the case of the opposite party, that OP was the Borgadar in this, my lord, he tried all the corners. Borgadar in respect suit land under Amorendranath Paira, and he delivered share of crops to Amorendranath Paira and got Borga receipt. OP further praised that the missed case is liable to be dismissed with cost. The only point for consideration in this case is whether the petitioner are entitled to preempt the case land on the ground of adjoining landowner. The application for preemption has been filed on, well, okay, this is also material, 16/9/81, and registration of the deed of transfer was completed on 27/7/81, so within time. Thus, the petition for preemption has been filed within the time, within the time. Further, the OP also did not raise any objection on the ground of limitation. Well, no limitation has been object. Let me now consider whether the petitioner are entitled to exercise his right of preemption in the property in question of the ground of vicinage. The petitioner, in order to substantiate his case, has examined as many as 3 witnesses. On the other hand, OP has examined 2 witnesses. What does
Nirupan Patra mean? What does Nirupan Patra mean?
Nirupan, family settlement in between the sons.
Conferring right title interest.
And definitely. So both brothers were holding jointly. Both brothers, Amarendra and Devendra, and out of that Amarendra sold.
You were saying Nirupan Patra is kind of settlement.
My family settlement,
Family
arrangement,
settlement.
family arrangement.
What does it say?
My lord.
What does it say?
There is
This
partition.
Nirupan Patra.
No, no, it is his own case that property has, kindly just previous.
No, I want to go by the document.
Well,
What
yes.
does that Nirupan Patra say?
Nirupam Patra is an arrangement made by the father in favor of his two sons.
Deed of settlement.
No,
That is deed of partition.
No,
That is Nirupon.
no.
Nirupon.
Do you have the copy? Do you have the copy of the deed with you?
My lord, I'm saying, my lord, there is no dispute regarding title.
Title, all right. I'm not on
And
title.
my lord, it is the case of the.
If Nirupan Patra indicates
Yes.
that absolute ownership was transferred upon the son by executing that deed, then co-ownership ceases.
My lord, father died. It was done. It was Nirupan Patra was made by Maheshwar. Maheshwar made it in favor of his two sons. Maheshwar died. Even if there is no Nirupan Patra, by devolution, succession, they will both the sons.
Then the complexion will be different. If there is no Nirupan Patra, if they inherit the property,
yes,
then they are inheriting as joint owners, co-owners.
Here also.
But when by way of an instrument, property
No,
is
if instrument, if it is separated or not.
Yes, that is why I am
My lord,
asking
he
you,
himself-
what does it mean?
What is his case, my lord? Kindly see, just he himself stated, kindly see. He himself stated. My lord, kindly see, this was reading. My lord, page 2 of the lower court judgment, page 2, last portion. Page 2.
That is finding.
Yes, the case of the opposite party. That is my learned friend's case. He was the opposite party there.
That is
What is
finding.
the case of the opposite party that petitioner are not entitled to preempt the case land on the ground of adjoining riot and the co-sharers. The OP, my lord, can see the OP further alleges. OP means him.
That is fine.
The OP, Tomar Boktobo, OP further alleges that the suit plot were never partitioned.
There is instrument.
আরে তোমরা নিজেরাই তো বলেছো ভাই
এটা তো finding.
না ফাইন্ডিং নয় OP further alleges it is not the finding. OP further
Do you
alleges.
have the copy of the deed, Mr. Chakraborty?
My lord,
Do you have the copy of that Nirupan Patra? I need to understand that. What does it convey? If it is transfer of property with demarcated land, then it cannot be a joint property. If it cannot be a joint property, there cannot be any co-sharer. If there cannot be any co-sharer, there cannot be any preemption. If the deed says otherwise, then you are the co-sharer and having adjoining boundary.
Entire case, my lord, says that remaining portion, no demarcation. This
I am
out of the
giving-
plot,
Being father, I am giving a part to my son
part
and
entire.
part B to my another son.
It is in favor of two sons, not part.
Two sons
Two sons.
indicating this portion will go to you, this portion will go to you.
No, my lord, only my lord.
Give me the copy of the deed better.
One paragraph কোথায়?
Because there is another element, Mr. Chakraborty. Admittedly, this gentleman transferred his entire share.
No, I have judgment to the entire share, my lord, out of the joint property. Out of the, I am the co-sharer. I'm joint.
What's the issue before the larger bench?
Larger bench, my lord, whether my
Entire share if transferred,
yes.
whether you can invoke section 8.
Yes.
In that event, I have to shelve this case till the issue is decided
lord,
by the larger
Well,
bench.
here, my lord, the holding is same holding. So entire share, how he can give?
Now holding doesn't carry any sense after amendment. Holding has been substituted. If I am not wrong.
Yes, the definition of land, my lord. My lord, here, my lord, kind
No, only point is whether the property was a joint property, co-sharer was there or not.
Yes.
For that, I need to go through the.
My lord, I want to cite one judgment, my lord.
No, but for that, we need to understand the fact.
Yes.
Now, in absence
My
of
lord,
that deed of
my lord,
Nirupan.
so far I have understood that my father, by virtue of a Nirupan Patro.
What is that Nirupan Patro? What does it
Well, it
convey?
is the case of the.
No, what does it convey? You have acquired the title by virtue of that Nirupan Patro. Or your father,
My father, my lord.
Your father acquired the property on the strength of that Nirupan Patro.
No. Yes. Now,
Your father and your uncle. You are the legal heirs of Devendra, or what is the name?
Devendra, yes, I am the legal heirs of
Devendra. Nirupan Patra was given by
Maheshwar, Devendra's father.
Maheshwar executed Nirupan Patra in favor of his two sons.
Devendra and Amorendra.
Amorendra. You were claiming under Devendra.
Devendra.
Amorendra sold his share to the petition to the opposite party.
Undivided share.
Now, according to you, it is undivided.
No,
But
according to him also. According to him also, my lord, kindly see the revision petition what says. I'm again reading.
Where is the deed? Let me go through the deed.
Kindly see the revision petition itself.
Let me go through the deed, Mr. Chakraborty. Deed that will give.
Let him bring the deed.
Do you have the copy?
Not today now. I am not with that Nirupan, deed of Nirupan Patra.
Yes.
But in my
you forget about what you have said.
It does not stick in that point.
In my deed of purchase, that is there. That Khejuri Sub-Registry Office 3557 রেজিস্ট্রিকৃত নির্বন দলিল মূলে আমি প্রাপ্ত হইয়া অদ্যত বিরুদ্ধে সত্য আমার লিখিত নির্বন পত্রে প্রাপ্ত সত্য দখলের নিম্ন তফসিল করিত।
Listen to me. I am bequeathing a property by executing a will in favor of my two sons, leaving aside four others.
I am not with the Nirupan that place.
In the event of probate being granted, those two sons will become co-owners in respect of the property. If I transfer it by way of gift, jointly, they will become joint owners. But if I transfer with definite demarcation, then they will become absolute owner in respect of the property allotted. That is the key point that needs to be understood.
Separate Khutian to be.
That is then since they are the
So better you wait till the larger bench decide the point.
No, my lord, I am citing one judgment, my lord.
Judgment will not do unless I understand the fact.
Or the deed of Nirupan Patra is with them.
Please. What does it convey, Mr. Chakraborty?
পত্র আপনি দিতে পারেন না।
আমি তো ফার্স্টে আমাকে থাকবে না, আপনারা মালিক হচ্ছে আপনাদের কাছে থাকবে, আমাদের কাছে থাকবে কেন?
For my understanding, I need to. This is for the first time I am coming across such terms. Yes.
Let us hunt whether we can get this.
That is the
only key point.
No, by his revision petition says remaining portion of plot number. So this my lord indicates that
it is a joint property.
Joint property. Himself, my lord, kindly see.
Your friend perhaps has the Nirupan Patra. Now, if it is a joint property,
Nirupan Patra is the originally I was engaged in the matter. It was time to time hard. Even to the extent it was matter of was for final everything, but a judgment justice post he was demoted to that post. It was CAB. My learned friend Chief Justice of City Civil Court. This is possibly Rohita Danpotro, Maheshwar Kora, Devendra Amorendra. Original. Possibly,
the only thing you please find it out whether definite portion was transferred.
Yes.
This is the fact. These are the dark numbers. Out of that,
dark numbers.
12 decimals are there. 3 Amorendra, 9 Devendra.
Here, 4 decibels of that.
Sri Amorendra.
That's why
Sir, Sri Amorendra 911 whether with definite demarcation.
it speaks for itself.
So that is what I want to say.
Petition.
Oh, should be separated by document. आपने तो बताया revision
Mr.
petition himself.
Chakraborty, either you assist me in disposing of the appeal or I shall shelve it till the matter
No,
is
my lord,
decided by.
my lord, kindly, my lord, party, my lord, this, my lord, kindly see, this is a, my lord, this is a matter of my lord, of the year.
I don't quite say.
My lord, kindly see how long.
Do you have the copy of that instrument?
Yes, yes.
Nirupam Patra.
81, my lord.
Do you have?
60 years, that's why I'm trying to make it. My client is here, I tell him whether he get it or not.
My lord,
Okay.
this is the, my lord, kindly see.
This is the Nirupan Patra.
Yes. Nirvan Patra.
No.
আরে বাবা এটাই
This is the Mysore Korea,
হ্যাঁ এটাই
Devendra Amorendra.
this is not countable এটাই unnecessary একই এটা কোন সালে
68.
68 এটাই since 81 parties are suffering 81
9 times it was
40 years proceeding is going on 40 years. There should be an end of it. You have deposited the money and they are enjoying the property. Entire consideration has been deposited by us. পুকুর আছে বন সেইটাই তো কথা পুকুর তো আছে মাছ ধরে না শুধু দেবো আর কি আর টাকাটা করে জমা করে বসে আছি আর তোমরা খেয়ে যাচ্ছে কাঁচলা দেবো
Mr. Chakraborty, have a look at this deed. Definite share, definite area with definite demarcation transferred not only to his two sons, to his grandson as well.
Then there are co-sharers.
There are no.
There are co-sharers.
How could there be co-sharers? You read the document, you will get the answer.
No, whether by this, my lord, a person during his lifetime can make this partition.
No, this is not partition. This is absolutely a deed of transfer, deed of gift, transferring the right of the owner in favor of three persons, leaving aside one of his sons, who according to the donor or the maker of the instrument is indisciplined. So he has given the property to two of his sons and one grandson with definite demarcation. And with further direction to get their name mutated in terms of the schedule of the property.
Whether mutation of separate Kotian.
That I don't know, but the document says it was a transfer in presentee. You go through it. You go through it.
Much of it. I shall go, my lord.
For what? What makes you so obliged?
No, since that is pointed out and detected.
No, you are, he has himself stated that.
No, that is finding. That
Unparticipated.
is erroneous finding
Erroneous finding.
of the learned court below.
No, that is not a finding. That is
Not
your
a fact
submission.
that
his
That is
finding.
your submission.
No,
You
that is
better-
recorded.
Mr.
Not a
Chakraborty.
fact that I have my written.
Wait, please, don't make it hard. You read this document and you come back with your finding, whether I am wrong or
All right.
it is correct. It appears to have been transferred in presenting. So absolute ownership in respect of the properties,
I shall go.
you please go through it and come back. And bring one photocopy, one more photocopy for me.
My humble submission, may I have it?
No,
My lord, be kind enough to get it, please to direct.
one further submission will cost you 5,000 rupees to be paid to SLS.
We should have.
So better you keep your and bring one copy for me.
Yes,
When should it be fixed?
tomorrow.
None. Next week, eh? 21 July কবে?
You come on 21 July. 21 July.
That is also a penal measure.
এটা ফিক্স করে দিন 21 তারিখে।
21 তারিখে বাদ দিয়ে। 20 আজকে
কে আছেন ওখানে? Heard Mr. Mukherjee, learned counsel for the petitioner, and Mr. Chakraborty, learned counsel for the opposite party. The matter is adjourned to appear on 31st of July as parted. 31st of July as parted. Yes, next one.
as forwards or 2 PM or
As parted, Mr. Chakraborty will come back. Then
can we fix up a time 2 PM or item 20?
as the business of the court will permit. It may be at 10:30, it may be at 4.
As well as.
And if you are not found in courtroom, appropriate order will be passed. You are doing civil matters since how long? For how many years? What does Nirupan Patra mean? What's the point? Nirupan Patra. Yes, deed I understand. But what kind of deed? What's the nature? So,
Actually,
so you are to assist me in this matter.
Nirupan Patra is family settlement. I have seen it.
You have not come across any such thing. You have come across Nirupan Patra. What is that? Anyway, you come back to assist me. What is that?
No, that is sleep for recording the name. For recording the name, that is sleep for the petition.
এই পরের ম্যাটারটা ডাকুন তো।
এই ধরুন।
Nirupan indicates some decision, but what does it decide? That is the question.
Let's check.
Instrument. No, Amolnama is prior to Bengal Tenancy Act. There is an indication Amolnama. Amolnama is something different.
It was included doing that.
I call the list. Passover কোন ম্যাটার আছে? আর কোন Passover ম্যাটার নেই? কোনটা আছে? চট করে নেমে যাবো 3টে বাজে। ফুল কোর্ট রেফারেন্স আছে। 36 কালকে বললাম না? For the appellant.
Yes, my lord, this second appeal is accompanied by an application for appropriate order that is also there, my lord.
What is the application?
Application for appeal. What happened, my lord? I filed a second appeal. Appeal was admitted. Then in the midst of hearing of the matter, it was known to me that one of the party respondent number one and two, their main party who happens to be brothers and who filed joint statement contributed the matter jointly. Then, my lord, it was brought to my notice. I made an application for substitution. It was allowed. My lord, I made the names incorporated on the basis of intimation given to me by the learned advocate. But subsequently, my lord, they filed a fresh Bhokalatnama. From the register office, it was reported that Bhokalatnama is not tallying with the names. There are certain mistakes in the name. All these things are there. On that score, my lord, matter came up before the learned register Lojima court, and they reported that I have to make a fresh advocate appeared, and I have to make a fresh service of notice. Facts remain, my lord. It gave me much pain in making their presence. My lord will find from the records, respondent number one and two, but one of the party was not appearing, in consequence of which, through paper publication, their presence was secured. Ultimately, my lord, this has been done. My prayer is very simple. If the Bhokalatnama, as per Bhokalatnama, either allow me to correct the substitution petition or allow it, so that matter can be made ready. Lordship, that is my substantive.
1A, 1D.
1A. Lordship, kindly.
Do you have any document that was given to you in compliance of Rule 10A?
Yes, this is the names they have supplied.
Yes, how it was given? What were the names?
Meera
Did you
Saha,
follow
page 15?
Page
15.
50 of?
15, 1-5.
1-5 of?
1-5 of my CAN 5 application.
Your CAN application. Hey, Aditya, দেখুন তো কোথায় কি CAN application কোথায় কি রয়েছে?
CAN 5.
CAN 5.
CAN 5, 2023.
What's the old number? CAN 4. দেখুন কোথায় আছে? Do you have copy?
Yes, I have one copy. Let me check. The list will endorsed their application CAN 5. In the list, it is there.
Do you have copy of the petition?
I have 14, it is not complete in itself, my lord, and extras are not there.
দেখুন তো কোথায় এখানে কোথায় CAN 5 তো দেখছি। দেখুন যদি
appropriate order.
কোথায় আছে ডিপার্টমেন্টে কি করছে এটা? Sorry, copy of petition if you
Lord, I
can
can make
provide.
one copy. If the matter is taken up tomorrow, I can make one copy. I am sorry, my lord,
Better you come back because
let it be
petition is
tomorrow,
not
my
with
lord,
the
because
record.
I will prepare another copy, my lord. I have got the petition and extension not with, I cannot give you, lordship.
এটা এই করুন তো এই ডিপার্টমেন্টকে সেকেন্ড অ্যাপিল ডাকুন কোথায় বার করতে হবে you come back tomorrow with a copy in the meantime let me see what the department is doing এটাকে বলুন এটা বার করে দিতে ডাকুন correct এটা।
I have put the appellant applicant, my lord. This is one for the substitution.
I'm for the respondent.
And two for the, my lord, condemnation section 5 application on immediate suggestion. But this is my immediate side.
You are the sole respondent.
No, I'm not the sole respondent, but I have been substituted. And first of all, my lord, preliminary.
Just wait.
During the pendency of this, this is a judgment of reversal. Suit was filed by the plaintiff. That was
Suit was for
declaration and injunction.
Hmm.
But that was dismissed. And challenging the same, the plaintiff filed a first appeal. That was allowed. Challenging the same, I am this court before this court second appeal matter. It has not been admitted. But in the meantime, during the pendency of the second appeal, one of the plaintiff, my lord, namely Khokon Pramanik died on 30th May 2021, my lord. During the pandemic, my lord. There is a, my lord, and thereafter I filed this application on 1st April 2022. Apparently there is delay, but pursuant to the judgment of the Supreme Court in special bench, there is no delay, my lord. My lord, limitations should be counted from 1st March 2022, my lord. This is the judgment of the Honorable Supreme Court. My lord,
yes. Now, according to office report, how many days delay?
My lord, it is our calculation. There is 216 days delay, but as per the order of the Supreme Court, my lord,
No. What is the report of stamp reporter? Did he indicate anything?
No, there is no remark, my lord, in the causalis, my lord.
So, who has pointed out there was delay?
My lord, we have counted.
Anyway, Khokon Pramanik is dead.
My lord.
Yes. Well, preliminary, I have objection to the section 5 application.
Yes, why?
Well, the grounds which have been taken in the paragraph number 3. So only
make
one
your
has-
submission in the light of direction of Honorable Apex
Supreme
Court.
Court, my lord.
Yes, my lord. I'm
Now
not-
everything is covered by
Yes,
that.
yes. But only thing is this, my lord, that after 31st March 2022, why the delay has been occurred, that has not been explained.
My lord, after 31st of 90 days, there is before, my lord, there is no delay. My lord, kindly see the paragraph number 5 of the Honorable Supreme Judgment, my lord.
Can't you eschew this habit of interjecting the other one?
My lord.
Don't interfere. Let your friend make his submission. Don't at a time. Yes.
And my lord, this is my only objection. And
No, the gentleman died on 30th May 2021 during the pandemic. Now, this application, when
1st April. 1st April 2022, my lord.
2022,
My lord.
and the protection was till 28th
Protection
of
was till,
February.
my lord,
28th of February 2020.
February. And my lord, limitations should be counted, my lord, from 1st March 2022. Thereafter 90 days, my lord. Paragraph 3.
Yes, fine.
Yes.
but, has been affirmed on perhaps
When?
17.
31st March 2022, it was filed, filing clerk. It was affirmed. Then does it matter really? Affirmed on 31st March.
Yes, ma'am. 1st April filed.
Only this substitution application is pending.
Yes, my lord, substance application pending. And until and unless it is substituted, I cannot take step for admission, my lord. This is the appellate side rules, my lord.
Why can't it be done before the Lojima court?
My lord, it is not within the time. Apparently delay, but transferred to the Supreme Court, there is no delay.
No, there is certain direction upon you. Why can't you remove the defects? Names of the minor pro forma respondent number 3 and 4 herein is bereft of representation. Minors must be represented through their legal guardian.
Natural guardian, my lord. My lord, there are, my lord, I have stated there are major and superiors, my lord, sound mind. Three of them are regarding the substitution.
No, Sukanto Pramanik, minor son. Momita Pramanik, minor daughter. Pro forma respondent number 3 and 4. That is the office report. You remove the defect.
My lord, I shall remove, my lord.
You are not taking any steps.
One week is now. One
Now, who has advised you to come before this court? How the matter is appearing? It was appearing before the Honorable Division Bench all along.
My lord, at first, this is the, my lord.
The department indicated certain irregularities, nothing on substitution.
My lord, I have consulted with my lord, senior, my lord, advised me at first, this is before the landed single bench. Landed single bench will allow the substitution application. Thereafter, it is, my lord, should be go before the my lord, division bench for order 40 on rule 11 for admission. My lord.
No, department did not indicate that it is barred by limitation. Or sorry, your substitution as stands
Yes,
corrected. Yes.
My lord,
But substitution, why before this bench? It should be taken up by Lojima.
my lord, because there is delay, as the 216 days delay. My lord,
Who has pointed out?
my lord, we have filed, apparently it is delay, but pursuant to the Supreme Court judgment, there is no delay. Apparently it is delay, my lord.
Well, once he is taking the advantage of the Supreme Court judgment that every delay is wiped out. So 216 days delay cannot be counted. Now, according to him, Millard, so after 31st March, there is no delay.
No, what he is on is after 28th of February 2022, limitation starts.
Yes.
And from 1st March till 90 days, he is entitled to file the appeal or application without any petition for condonation of deed. Do you agree with him?
No, I disagree, completely disagree with him.
Why?
Because Millard, that's judgment, Supreme Court judgment, what my learned friend is relying upon. So, my lord, So far my knowledge, right now I have no judgment. Subsequently, Supreme Court, perhaps Supreme Court passed another judgment that না ওটা এই জাজমেন্টের কথা বলছি না এটাই তো জাজমেন্ট হচ্ছে কথাটা কি বলছি শোনো জাজমেন্ট দিচ্ছি তো আরে কথাটা কি বলছি শোনো আমি এই জাজমেন্টটা জানি এটা আমি বলছি না in another judgment perhaps Supreme Court expressed their view that the delay which has been occurred in the COVID period by virtue of this judgment that cannot be could simpler way take advantage of that situation.
Where is that judgment?
Right now, I have no judgment. I have not been that judgment.
See, if you are pressing certain point, you should come ready.
Already, I have stated paragraph number 3. Due to pandemic.
So, my lord, this is my submission, and so far as the delay is concerned, that's leave up to my lord. My lord.
You are respond number 1. You are respond number 1.
Yes, my lord.
Yes.
Substituted respondent. Yes. No, whom are you representing?
Yes, my lord.
Whom are you representing?
Krishna Pramanik, Manik, Putul, and Bablu.
They are pro forma.
No, they are the
No.
They are the plaintiff appellant, plaintiff, my lord.
All are the legal heirs of the Khokon Pramanik. That is respondent number 1.
All legal heirs, sir.
Khokon Pramanik.
They are already on record.
Two is the not the my lord substitution. It is not the legal.
You have taken out an application for substitution of Khokon Pramanik.
Yes.
Now your friend is saying, I am representing the legal heirs of Khokon Pramanik.
My lord, two is the not the legal heirs of the Khokon Pramanik. They are the son of Jitendranath Pramanik.
No, I'm not asking this thing.
My lord, he is saying, my lord, not one ABC, my lord. I have
One,
said
yes, one Krishna Pramanik, one B Manik Pramanik,
and one C
Putul Pramanik.
Yes.
You are representing these 3 persons.
Yes.
When did you file Wakalatnama?
30th June 23.
30th June 2023.
Yes, my lord.
Yes. What is this then? Can 1 of 2022?
Cannot. This is the substitution application, my lord.
Substitution application.
Yes. Two is
And legal heirs of the deceased respondent,
yes.
they are already on record.
No, they are already on
As
record.
1A, 1B, 1C.
1C. My lord, that is in my substitution application. I have to my lord pleaded. Otherwise, how can be there substituted?
Then how could he appear representing those 3? He is representing 1A, 1B, 1C.
My lord. As the my lord, this is an application. So I, my lord, serve the copy. This is an application. So I serve the copy of this application. Until and unless I serve, my lord, how can I move it?
You serve upon whom?
My lord, upon the my lord, the legal heirs of the Khokon Pramanik.
And what about others?
The others I have served also. Other I have also served. So by
You have submitted Wakalatnama.
Yes.
So your job is done.
I have served also other.
None is appearing pursuant to service of notice except the legal heirs of Khokon Pramanik since deceased, who have been depicted as respondent number 1A, 1B, and 1C. Stop. Mr. What is your good name?
Taposh Maiti.
Taposh Maiti, learned counsel representing the respondents 1A, B, and C, submits that the legal heirs of Khokon Pramanik have already entered into appearance and he has submitted Vakalatnama way back in June 2023. Stop. In this backdrop, the disposal of application for substitution remains a mere formality. You were seeking substitution of these.
Yes, yes, my lord.
They are already on record.
They are already on, oh, I have bring them on record. My lord, I have bring them on record.
Ki bolam? Under such circumstances, application for substitution remains a mere formality. Stop. Since the legal heirs of Khokon Pramanik, who died intestate on 30th, who died how?
Due to, my lord,
Testamentary or intestate? Huh?
COVID, my lord.
Due to COVID, I understand. Died intestate or there was
Yes, they died in this, I have written, I died in.
where you have written it?
Yes, ma'am.
Come to your paragraph 2.
My lord, the Khokon Pramanik died on April.
As intestated, died intestate on 30th May 2021, leaving behind Krishna Pramanik, Manik Pramanik and Pallavi alias Putul Pramanik as his legal heirs and successors.
Paragraph 2.
Stop. Who are, as I have pointed out, already on record. Under such circumstances, the application being Can 1 of 2022 is disposed of. Let the matter be placed before the appropriate bench.
Extremely good.
Court document, take it. Ready? There is full court reference, no? হ্যাঁ ঢুকে গেছে ওরা অ্যাপিয়ার করে ওকালতনামা দিয়ে দিয়েছে
But in item 41, I appear for the respondent number 1.
1.
Yes, my lord. Lord, yesterday, when the matter was called on, my lord was pleased to ask me whether the services which are affected on the respondent number 1 on behalf of respondent number 228, my lord was pleased to ask me what is the status actually.
Yes.
My lord, the service is not yet complete because the respondent number 1 has given Vakalatnama to me, which I have filed in the department. And the
not only that, he has received the
on behalf of the state also. My lord, the process server who went to serve the notice of the appeal,
yes,
he handed over everything to the petition.
And your client merely accepted
that thing
on behalf of all.
On behalf of
so
all.
Technically service is complete.
This is the
আমি কার্তিক মন্ডল বিবাদীগণের পক্ষ হইতে সমনগুলি
without understanding everything, he has taken it.
Ignorance of law doesn't matter, doesn't count.
But I believe that ignorance of law does not count, but at the same time, that ignorance will be proved that the service upon which was supposed to be affected upon the collector of the South 24 district, that has also been done upon him.
No, that
I believe the service is to be done.
Yes, Mr.
And another thing, my lord, from the record, I find that paper book has been filed, but nothing has been served upon me.
I'm not obliged.
You collect it,
I have not yet received any notice, but
So
they
that
have
is
served.
not their problem.
But,
Yes,
but they have served.
Who is there? He's the advocate for the caveat. He has lodged caveat, I have served. He has lodged caveat.
The advocate for the caveator who's lodged the caveat, the advocate, he has given no objection.
That is not my
He has
point.
given no objection.
He should not have accepted this.
no objection.
How
How
could,
do I know,
how-
my lord?
how could your adversary will know that you have taken a change brief?
My lord,
And even if, my lord, I have no obligation to serve upon it, it's my obligation to file in the department. Whoever collects it from the department.
Anyway, it is lying in the department, you collect it.
I will do, I will collect that. But the thing is
And
that,
find out your friend who is,
my lord, one thing, there has been occasion previously where I have appeared and he also appeared. He knows everything and knowing fully well, he has not served. This is my submission, my lord. But unless the paper
Anyway,
book
and
is
yes, what is next, what is left?
Somnath Gangopadhyay.
No, today is for,
Hearing of the appeal,
How the hearing could be done?
hearing is, it can be done. My lord, the service of other respondents are not necessary. at all.
no, he need to collect the paper
No,
book.
that is, that will-
You collect,
Paper, if my learned friend insists, then
yes. What is his name? Mr. Ganguly or Gangopadhyay?
Gangopadhyay.
Gangopadhyay. What's the difference basically between the two?
Bengali, British
there
used
are
to produce
British
Gangopadhyay.
used to use the Gangopadhyay, Ganguly, Banerjee, Chatterjee, Mukherjee. Actually,
So Gangopadhyay, if referred to Ganguly,
yes.
it will take out the glamour.
No.
Then
Used to at that point. of
at
time.
that point of time, you
Actually, these are all Upadhyayas.
Well, our beloved, Mr. Our learned senior advocate, Mr. Iraq Mitro, his meter,
Yes, Mr. Gangopadhyay, learned counsel representing the respondent submits that he is yet to receive the copy of the paper book. No notice has been served upon him from the department. Stop. Under such circumstances, I am adjourning the hearing of the appeal. Mr. Gangopadhyay is requested to collect the paper book from the department. Is requested to collect the paper book from the department. Service is otherwise complete, as I find from the endorsement made by respondent number 1. Suggested date. Suggested date. 28th, 31st, monthly list.
But I have some difficulty.
But 27th, 28th, 28th, my lord.
This
30
month, some difficulty I have. I have some difficulty
this month.
this month. I have some difficulty.
Then come back on 1st of August.
Yes.
The matter is adjourned to appear on 1st of August 2023 under the heading hearing of appeal.
Kartik Mondol, এক নম্বর,
Complete.
Soul, এক নম্বর defendant.
As I have found from the endorsement of respondent number 1. No more. 3:10 বেজে গেছে। 3:30 বোধহয় full call. Do you have any matter? Difficulty is we have full court reference.
Yes, my lord, 45 only section 5 application. Until unless allow the section 5, it's not possible to place that.
Very well, I will not attend full court reference. Give it. Give this 43, 40, 40, 42, 43. Ndakun. 43.
The application in connection with the second appeal. The order 41 has been admitted and the division bench also passed an order on 28th August 2019. And there is a partial order also injunction in connection with the application. But you kindly come to the order dated 28th August 2019. Injunction was giving the limited period that has been expired. Thereafter, matter was appeared before my Lord Justice Choudhury, and he also extended the order. This is the epidemic service. because they are disturbing my cultivation, enjoying this peaceful position.
Can 1 of 2018
Yes, this is injunction application.
and can 2 of 2019?
Two is Lordship, the order application under order 14 room 27. Lordship, at the time of
Oh, at the
trial.
time of hearing of appeal,
Yes.
not now.
No problem. Because the
Can 27655.
Lordship, yes,
So can 1 is pending. Can 1 is
pending.
for injunction.
Injunction, Lordship. 7655. of
Have you
2018.
served?
Yes, yes, it is served, Lordship. Why should I have served?
No, you have served in the year 2019.
No, thereafter, I think, thereafter, I think,
Latest.
2020, just today I have handed over.
এই দেখি affidavit of service
আজকে
কোথায় আছে?
আজকে যেটা দিলাম বিশ্বজিৎ সাউ
এটা না না এটা তো 19 সালে।
one I have given 2000
দেখুন এটা দিন
affirm on 5th দেখুন
সব 2019 এর ট্রান্সফার।
one is given affirm on 5th January 2021
5th January
2021
no 5th January 2021 when did you send the notice?
I have sent the notice, Lordship. This postal receipt, page 7, Lordship. This is
It's all 2019.
2019.
So
Yes.
you need to file afresh.
Then Lordship extend the interim order. Otherwise, matter I can heard. Lordship,
When the interim order was passed?
Lordship, first interim order, Lordship, kindly come. The order of division bench. This is 28th August 2019. Have you, Lordship, got me?
28th August 2019.
And thereafter, this interim order has been extended by the Malad Justice to later on.
Thirty-first of December 2019. Then
28th, Lordship,
after 31st December 2019, creating any disturbance in peaceful possession till the first week of November
Yes.
2019. It was
Thereafter-
already covered.
Thereafter, this order has been extended
When?
by
Last time it was extended till 31st December 2019.
31st December.
There is no interim order now.
30. Yes, Lordship. By Vivek the Malad Justice, yes, yes. Thereafter, Lordship, pandemic come, everything, I have tried lot of, the matter has just.
So how could I blow life to this interim order?
Lordship, when
It has expired.
No, that is the Lordship.
So you have to renew your application, your petition. with prayer for your
Lordship
interim
knows,
protection
Lordship knows they just now.
since
they took it in
2019.
Order regarding
Since-
the 2 years pandemic time, everything is.
Then
There are to after
it
lot.
came to end on and from 28th of first day of March 2022. We are now on 18th of July 2023. So
Lordship, very difficult to list it this second, very difficult. It is your Lordship's court in
What?
previous, well, I have mentioned.
well, I'm getting annoyed giving adjournment. You are saying it's very
No,
difficult
in
to.
this bench I have mentioned and matter has come. Before that, 655. Lordship.
You do
what-
one
what-
thing. Look, interim order, you cannot revive it. It has expired on this December
It is the
19th.
practice of the Honorable High Court Lordship, generally on the basis of this application. interim order
High Court
extended.
can show this magic.
Lordship, in this way we are practicing since that time.
Then wait for a couple of days. You have spent only 4 years. 2 months more will not do anything harm to you. I will revive, I will restore, I will dispose of your application. You just serve and come back.
It's very difficult to state the secretary.
Huh?
Very difficult. It is in our.
No, you
side.
serve and come back. Unless my determination gets changed, I am here.
We are lucky for that. We are lucky.
You serve and come back, don't question. Yes, Ninto. You are Mr. Shao.
Yes, yes.
Heard Mr. Shao. An application being Can 1 of 2021, 1 of 2018 for injunction is awaiting adjudication. The appellant is directed to serve upon the respondents afresh. Matter is adjourned for
Sir, I can tomorrow.
2 weeks
2 weeks.
with liberty to mention. Or should I fix a date?
Yes, yes. Lordship, kindly.
Matter is adjourned to appear on 4th of August.
Yes.
Then, মাঝখান থেকে আজকেও আমার পরে করতে আর পারলো না।
In this matter, I am for the appellant petitioner, my lord. Application under section 5 for condonation of delay in filing.
Pre-admission.
In filing the appeal.
Pre-admission.
Pre-admission.
Have you served?
Yes, my lord, every bit of service.
What is your explanation?
My lord, paragraph 6, 7 and 9, it has been stated, my lord, due to corona epidemic, the client did not deposit the requisite of the certified copy. For this reason, delay has been caused. My lord, paragraph 6, 7 and 9.
Let me see. This is your. Can number
1.
1.
Page 6.
This suit is for?
Suit is for declaration and permanent injunction. Plaintiff is the appellant.
184 days delay. But just for my understanding, stamp reporter is not indicating any such thing. When did you file the appeal?
On 8 June 2022, before this honorable. Second appeal has been filed, 8 June.
Rather, there was direction upon you to rectify certain defects. Have you seen that? 8th of June 2022. The decree was passed on 7th of April
21.
21.
1.
The period covered by the judgment of Supreme Court. And it continued till February.
February.
From March onwards, 1st March, April, May. From 1st March, 90 days. Ashun. Despite service, none is appearing on behalf of the respondents. This is an application for condonation of delay of 184 days from 8/12/21 to 8th of June 2022. It is contended that no, Udakani. Can one? No. The upon perusal of petition, I do not find anything to hold that the petitioner to hold that the appellant petitioners one appellant petitioner can be held responsible for such delay. It was the delay should be attributed to the tentacles, TENTACLES, tentacles of corona pandemic stuff. Having found the explanation to be sufficient, I am inclined to condone the delay of 184 days. Can 1 of 2022 is thus disposed of. Let the appeal be placed before the appropriate bench. There is certain direction upon you to remove the defects. Look into it. Okay, ওনাকে দিয়ে দিন তো।
My lord, I got the appellant, my lord. My lord, completely mercy petition, 304 days, my lord, there is lapses and negligence. 304 days, my lord.
304 days.
Yes, my lord, no negligence and lapses on the
Then
part
why?
of the
Then how
applicant.
could?
My lord, the matter in the code below, looking after one tout. He did not inform to the applicant at the time of filing the final order. Suit for declaration filed and permanent injunction filed by the respondent
You
number
stop,
1.
serve and come back.
No. My lord, then my respectful submission, my lord, only one player, my lord, kindly expunge, except applicant number, respondent number 1.
Why?
More than 70 respondent, my lord, my main allegation against the applicant number, respondent number 1. He got the decree in favor of it.
He got the decree in
his favor.
in his favor.
Yes.
Rest are the pro
No,
forma
No,
respondents.
pro forma.
They are siding with you.
Pardon, my lord?
Are they siding with you? Pro forma respondents.
More than
You need to serve upon all the parties.
kindly expunge.
How could I?
Because more than 70 respondents. my lord.
More than 70
But
respondents.
my
How many of them appeared in the trial court?
most of the respondents not appeared in the before the
So who are those? They did not
But
appear.
only respondent number 1 contested before the
Then
last.
you have to file another application expunging the names of those who did not appear and contest.
But my main allegation against the respondent.
Maybe, but you have arrayed them, depicted them as the respondents. They have the right. How could I foresee that they will not oppose? They will support you.
Then my lord, kindly adjourn the matter. I shall take instruction from my client.
When we are drawing the proceeding, now I cannot attend the full court reference, you know. Today there is a full court reference and I got stuck. ছেড়ে দিন এটাকে adjourn করে দিন. Yes, what's your good name, sir?
Bharat Chandra Simai.
Petition heard Mr. Shimai, learned counsel for the appellant. Can application number 2 of 23 can be taken up for consideration only after service, only after the service is complete. The appellant is directed to serve upon the respondents. Stop. Mr. Simai submits that the appellants want to proceed against the respondent number 1 who has bagged the decree before the who has bagged the decree. Stop. Liberty is given to Mr. Simai to take out application to get the name of the pro forma respondents who did not appear and contest the suit before the learned trial court expunged. You file an application indicating the persons who did not appear, did not contest, then you will be relieved of the obligation from notifying others. আর কি আছে একটা দুটো বার করে দিন আর কিছু ডিকটেশন দিয়ে দিয়ে তো একই হয়ে গেল একটা আদিত্য বাবু এইটা কি রয়েছে সন্তোষ কুমার হ্যাঁ গোপাল ঘোষ not to করে রাখুন Thank you.